Pattern to quickly mention my lord. Appointment under rehabilitation assistance scheme 2022 matter.
So, these mailers, item number 43 mailers. There mailers the release of 20 crores of rupees mailers to in respect of third party towards the mailers compensation to be paid for the land acquisition under the National Highway Act. I filed an IA mailers 12518 of 2024. May I pray mailers taken up on orders mailers next week?
That is there in the list.
Yes, item number 43 mailers.
Next week the orders my God.
Item to mention one restoration matter, my lord.
Yes.
Restoration. It has been dismissed for
Please give it, please.
item 36, my lord. Lord, Mr. Mahanti, senior Mr. Mahanti, after Mahanti is appearing in that case. His name is not appearing. So he is in a partner matter in today. He will
36, that is Ganapati Aluminium Balasore.
Yes, sir.
Yes.
Maybe next week, not on 27, 28, and 29. First week of December, my lord.
You are for the, you are
I'm for
mentioning
the petition. I'm for the petition.
So is there any interim order?
Interim order is answer 5 is not to be given effect.
So why don't you make a mention in the presence of the land and council for the other side?
Trying to find out where his node is.
The moment he comes, just we can. Yes.
Supplementary list, item number 1.
May I please, your lordship? Lord, I am challenging the order number next year 1, my lord, where the London Central Tribunal has rejected my amendment petition by applying the principles of Order 6, Rule 17 on the plea that the pleadings were complete, therefore the amendment is not allowed. The facts of the case is, my lord, I approached the London Tribunal against the order passed by the Superintendent of Post Offices, my lord.
Where is your amendment application?
Beg pardon?
Where is your amendment application?
Amendment application, my lord, your lordship will kindly turn to page 79. This document number 19, which I wanted to incorporate, was filed page 79, my lord. Annexure 6.
No, it's all right. What you intend to amend?
My lord, that
schedule is there or not? Schedule of amendment.
Schedule of amendment is there, my lord. You will also may kindly see. It starts at page 84. My lord, during the pendency of the original application, the CPMG rejected one of my representation, which was filed at the last date of hearing by the opposite party, my lord. And the tribunal accepted that one for the adjudication. That is why I wanted that my amendment amend the original application and prayed for passing that one.
To challenge that.
Yes, my lord. And now the tribunal has said.
Just come to that order, impugned order.
Order at Annexure 1, my lord. You also may kindly turn to page.
Please place in entirety because it is a 2-page order.
That is Annexure 1, my lord.
Right, place it, please.
We have considered, you can write. Proceed.
Page, my lord, 13. That last paragraph of page 13, you also may kindly see. Simply the tribunal has said.
Please,
no, you read it, sir.
Please place the entire order.
Yes, my lord. London applicant submitted that he filed MA number so and so for amendment since after completion of the pleading, matter being heard continuously. Respondent on 21/2/2024 produced order dated 30/4/2019, whereby order of the CPMG rejecting the prayer of the applicant for grant of full TRCA of the put-off duty period and confirming the order of the disciplinary authority. He submitted that the respondent had not filed the same during filing of the counter, reply to the rejoinder, etc. He submitted that the order dated 30/4/2018 need to be challenged for better adjudication of the OA. London Council for the respondent submitted that he has filed objection to MA.
It is either 30/4/2018 or 19.
That should be 19.
30/4/2018, my lord.
18. So earlier it is 19,
earlier
it is wrong.
Mention 19. See paragraph is
on
Please.
21/2/24 produced order dated 30/4/19.
Submitted the order dated 13/4/8. Yes, that is 19, my lord. I have annexed that one, annexure 3, my lord.
Okay,
All right.
19, all right. Then
Now, my lord,
please
uh,
complete that order.
the Learned Counsel for the respondent submitted that here file objection to MA, taking the ground that beside the proposed amendment would change the nature of the case. Amendment chart being filed when the matter was heard in part, the same is liable to be dismissed. We have considered the rival submission of the parties and perused the record. We have also gone through the rules 17, 6 of the CAT procedure rules 1987, wherein it has been provided that the tribunal may permit the parties to amend the pleading in the same manner as provided under Order 6, Rule 17 of the CPC. Provision to rule inserted in the amendment 2002 restricts the power of the court to allow amendment of pleading at any stage of the procedure. It says that the court cannot grant permission for amendment after the trial has commenced. It is not in dispute and cannot be disputed that the pleading in this case are complete. Matter was also heard in part. At this stage, the applicant filed MA seeking amendment of the OA, which is not permissible by the express provision made under proviso to Rule 17 as stated above. In the said premises, MA number so and so stands dismissed.
So if the original application is of the year 2018 and the order was passed on 30/4/2019, why you slept over the matter for so many years?
My lord, it
And
was,
when the argument started, then you filed this MA,
my lord, original application is filed in 2018.
right?
They say the CPMG rejected one of my
No,
application.
it must have been communicated to you.
It has not been communicated.
Where have you stated
I have stated
in
that
your MA?
in the, my lord, I have the writ petition I have stated.
No. You filed an MA for
Yes.
amendment. Have you taken that ground?
My lord, I have stated that it for the first time during the hearing it has been produced. You will also may kindly come to page.
No. Produced means who produced it? Who
Yeah,
produced it?
Other side produced.
Other side produced
Other
it.
side produced.
Yes, but it was already with you.
My lord, counter original application filed in 2018. The counter in that case filed, my lord,
You know what my lord is speaking, asking you
one
very
second.
clear.
Lordship,
Did you take this plea in your MA that this was communicated,
it has,
or it was never produced, never communicated to you?
I have stated in my MA, my lord.
So diligence is a question here, nothing more. It can be allowed, provided you have shown your diligence as to what prevented you not to file it earlier.
It is for 5 years.
Yes, my lord.
The order was passed on 30/4/2019 and this MA was filed after 5 years. There is no dispute about that.
No.
Question is that if that order was already communicated to you and it was within your knowledge and you are supposed to challenge the same, why you remained silent and why you came after 5 years when the matter was hard
At the verge of completion.
on the verge of completion?
Page 81, my lord, you will also may kindly come to that.
Yeah.
Paragraph 2, my lord. And in response to that, my lord, Lordship may
Where are you
kindly
reading, please?
Unless you read, how can you say?
page 81.
Page 81 ko line ko na the lines from the top ki kaun?
Paragraph 2, my lord. Paragraph
read
2.
it.
The applicant failed to understand the reason as to why the above order dated 30/4/19, even though was passed during the pendency of the OA before filing of the counter and a reply to disjointer was not brought to the notice of the tribunal by the
taking the responsibility to them why they did not produce. What diligence on your part?
Only one line, my lord. Only one line, my lord. Only one line. Your lordship will kindly turn to page 92, my lord.
And what objection they have stated?
Yes, exactly. I'm taking to your lordship. Page 92. Page 92, paragraph 4.
Paragraph?
Page 92, paragraph 4. In reply to paragraph 2 and 3 of the MA that I was reading, it is replied that though the said order dated 30/4/2019 of the CPMG was not produced inadvertently, but for proper adjudication, the same has been brought to the knowledge of the tribunal by way of affidavit. That affidavit was filed on the last date of hearing, when 7 occasions the matter was heard. I have given those dates, my lord. In my writ petition, you will also may kindly come to page paragraph 2 of my writ petition, my lord.
So, admittedly, you have not taken a ground as we are just telling that this particular order under Annexure 3 has never been communicated to me, for which I was not aware that my representation has been rejected. Hide Annexure 3 in 2019.
Until it is
That
produced.
specific ground has not been taken in your MA.
I
Is
have
it correct or not?
It was discussed in the court during the hearing, my lord. I have stated that it has not been communicated. And that is a fact,
Okay,
my lord.
Mr.
Only
Padi,
one thing more.
just
One thing more, my lord.
just a minute.
The rule says, my lord.
Please wait. Mr. Padi, please unmute yourself. Please unmute
Yes,
yourself.
my lord.
Somebody has filed a representation and you are rejecting the representation in 2019. Whether it was or not on the part of the authority to communicate the rejection order to the party or not.
But it is listed for first time. I don't have that instruction. But thing is that he has submitted representation at press, and the press cause of action arose to file another application if they agree with the order of the representation. Once a matter is in sub judice and it is come to a concluded hand, and if file in the meantime representation dispose of what they have submitted in the argument before my lord, and if the representation, if they have any grievance, the press cause of action arose, they can file another application, and they soon either.
What they say that it relates to the same thing. Matter arises out of the cause of action is one and same. In the meantime, while filing the original application, they have also preferred the representation. No, there is no dispute that they could have also challenged it in a separate original application, but it would have delayed the matter
And
because
multiplicity of
it is a
litigation.
multiplicity of.
Yes, I understand, my lord. My lord,
No, we just wanted to know from you that why did
let's give 2 weeks time in the meanwhile after this.
Because if he was he says
Yes,
that
I got the point, my lords. Yes, good. Yes. Then no further
all right,
litigation.
you take instruction in the matter.
Yes.
This writ petition has been filed by the petitioner Sudarshan Kaur, challenging the order dated 29/4/2024 passed by the London Central Administrative Tribunal, Cuttack Bench Cuttack, in MA number 187 of 2024, which arises out of OA number 575 of 2018, with a further prayer to allow the amendment as per the prayer made in the MA. And for a direction to the London Tribunal to allow the amendment in the OA sought for fair adjudication of the original application. The London Counsel for the petitioner submits that the petitioner preferred OA number 575 of 2018 before the London Central Administrative Tribunal, Cuttack Bench Cuttack. Where is your prayer? Which page?
Yes, sir. That is 10.
My prayer was to grant that a put off duty period if they treated it as non-duty.
To set aside the order dated. Where is your prayer?
29/4/2024 under Annexure 1.
There the superintendent had rejected my prayer, my lord. That is why I challenged that one.
No.
No.
Application of prayer.
Prayer was, my lord, you will kindly get it at page.
Writ petition, page 10.
Page 28, my lord. Page 28.
No. 10.
original application number.
original writ application जोटा तार prayer दवा
Why you filed the original application?
I had filed the original application.
କିଛି ପାରୁନାହିଁ ମତେ irritate କରୁଛି
ମାନେ OA number
575 of
ଏଟା ଟିକେ ଦେଖିଦିଅ ଏଥିରେ last order sheet
So that
ଅଛି
is
page
not
that starts at page 15.
ପୁରା ଛାଡି ଦିଅନି
28 ଲକ୍ଷ୍ମୀ ପାଇଁ
ଲୋକଙ୍କୁ ରଖୁଛି
page
ଏଥିପାଇଁ
20
ଯେ ଏଇଠୁ
prayer in
basis
the way.
ତାକୁ ଛାଡି ଦଉଛ last order ଜାଣିନି କିଛି ଶୁନି ଯିବା
The prayer in the way is at page 28, my lord.
Okay.
That the superintendent passed a order. I prayed that my put up duty period,
just a
that
minute.
suspension period may be treated as duty.
Just a
He
minute.
said
Just
that
a
I
minute,
don't have
sir.
Just a
power.
minute.
Page 28.
Please have
Wait,
your
wait,
patience.
sir.
With a prayer to quash the part of the order in which the period of suspension has been treated as no work, no pay, for all purpose, had annexure A by 5 and also order under annexure A by 12, where the superintendent of post has requested CPMG Odisha Circle to review and treat the period of suspension as duty for the purpose of pensionary benefit, inter alia with other prayers. The opposite parties entered appearance and filed their counter affidavit. And after the pleading was completed, when the matter was taken up for hearing for several dates, the petitioner filed MA number 187 of 2024 in the said OA number 575 of 2018 with a prayer for amendment in the original application. According to the Land Council for the petitioner, while the matter was sub judice before the Land Tribunal in OA number 575 of 2018, the representation filed by the petitioner was rejected by the Chief Postmaster General, Odisha Circle, Bhubaneswar, on 34th, 2019, by Annexure 3. However, the petitioner was not aware about the passing of such rejection order, which he came to know for the first time when the Land Council for the opposite party produced the same at the time of hearing of way number 575 of 2018.
On 6/3/2024.
On 6/3/2024. The opposite parties filed objection to the miscellaneous application, and the Land Tribunal filed order dated 29/4/2024 has been pleased to hold that though Rule 17(6) of CAT Procedural Rules 1987 provides that the tribunal might permit the parties to amend the pleadings in the same manner as provided under Order 6, Rule 17 of CPC. But the proviso to such rule inserted in the Amendment 2002 restricted the power of the court to allow amendments of pleading at any stage of the proceeding. It says that the court cannot grant permission for amendment after the trial has commenced. According to the London Central Administrative Tribunal, since the pleadings are complete and the matter was heard in part, at that stage, the MA application filed by the petitioner seeking amendment of the OA is not permissible in view of the express provision made under the proviso to Rule 17. When we put a query, made a query to the London Council for the opposite party, Mr. Padhi, London Deputy Solicitor General, who is appearing with Kahana Lekha
Suluchana Patra. Suluchana Patra.
London Central Government Advocate, that whether anything there on record that the order under Annexure 3 rejecting the representation of the petitioner was communicated to the petitioner. The London Council for the opposite party 6 times to obtain instruction in the matter. Issue notice on the question of admission indicating that the matter shall be disposed of at the stage of admission. List this matter. Fix a date in the month of January. Counter affidavit if any be filed in the meantime. IA issue notice, accept one set of process fees. You are appearing for all the opposite parties, Mr. Padhi?
Yes.
Mr. Padhi accepts notice on behalf of all the opposite party. No notice be issued for to opposite party number 5. Yes.
Obliged.
Item number 2.
I'm praying for such adjournment, madam.
When do you want?
Next week, madam.
Have you, it is a fresh matter, any interim order?
No, fresh matter.
No, my lord.
Fresh matter.
Fresh matter.
Land Council for the petitioner seeks for an adjournment till next week. Please this matter will be commencing from 25th November 2020. Okay.
Obliged, madam.
Item 3.
If my learned senior may provide me a copy, I can assist you.
You are appearing for which opposite party?
Opposite party number 3, at whose instance the proceeding started.
No, it's all right. You have already filed your power.
Yes, my lord. My name is reflected.
Okay. Give him a copy.
Yes.
Mr. Amit Prasad Bose, London Council, submits that he has already appeared for filed Vinama for opposite party number 3, Shivanand Agrawal, and let the London Council for the petitioner be asked to provide him copy of the writ petition. You give him during course of the day or by tomorrow?
Yes, sir.
Let the copy of the writ petition be served on Mr. Bose by tomorrow. Anyone next week?
Yes.
Publish this matter in the week commencing from 25th November. Yes. My lord.
Item 4.
May I please your lordship? My lord, this is a land acquisition case where the petitioners filed the award has been passed and compensation amount has been paid, but it has been paid to the vendor of the petitioner. Petitioner is the purchaser and in possession of the property, but at the time of
he has not disclosed that he has sold the property to you and received the compensation.
Received the compensation. So the petitioner ventilated his grievance before the collector.
Representation
Sir, annexure 5, my lord.
6 na 5?
5, 6, 6, my lord.
6. To also file representation by annexure 6. Time limit 3 months from the date of production of the certified copy of the order along with the copy of the writ petition. 15 days time to within the disposal, it is to be communicated to the petitioner. He has disposed of it.
Item 5.
Yes, Mr. Patnaik.
Well, sir, I'm sorry. That file is not with me, and I do not know whether I have filed the file or somebody has filed or somebody other.
Whether you have filed or
some other name is there. Vijay Kumar Patnaik.
Please see the Vinama. Upon dekhi that Vinama.
Vijay Kumar Patnaik.
My name is there.
No, no. You say that there may be some other. So that is why. Please see the Hinama. That is. Hinama ଅଛି ପରା ସଭା ଆପଣଙ୍କର
ବିଜୟଟା ଆପଣଙ୍କର ବିଜୟଟା ଆପଣଙ୍କର
ଆପଣଙ୍କ ଅଫିସର ତ ଅଛି ତ ନାଇଁ ନାଇଁ ଠିକ ଅଛି ନାଇଁ ଆପଣ କଣ ବ୍ରିଫ ହଜି ଯାଇଛି ନା ଦରକାର ଯଦି ପେନ୍ ଡ୍ରାଇଭ ରେ ଦେଇଦବା ଆମେ ଅଛି ଆପଣଙ୍କ ପାଖରେ ପେନ୍ ଡ୍ରାଇଭ
ଫଟୋକପି ଦେଇଦବା
ଫଟୋକପି ଆମକୁ ସଫ୍ଟ କପି ଦେଇଦବା ଆପଣ କରିବେ ଯଦି ବ୍ରିଫ ହଜି ଯାଇଛି ନା ଖୋଜିବେ ଚାମ୍ବରରେ
ଆମେ ଦେଇଦବା ଫଟୋକପି କରିଦଉଛୁ
ଓକେ
ଆପଣ ନେଇଯାଉ ତ ବ୍ରିଫ ଦେଇଦେବେ
Mr. Vijay Kumar Patnaik, Land Counsel, for the petitioner, 6 for an adjournment. केबे रखिवा कुंदु? केबे रखिवा आरो सप्ताहे ना गोटे सप्ताह? Place this matter in the week commencing from 25th November 2024.
ठीक से छटा भी आपणकर
हाँ दुईटा
Item 7.
My friend. Petition is the successive purchaser, my lord. Initially, my lord, in the year 71, my lord, the lease was granted.
What is your prayer, Mr.?
My lord, it is a cover order, my lord. That was the Naratham Ratha, that judgment, my lord.
Covered order can't hear about it.
My lord?
Why it is covered?
My lord, without giving any opportunity of hearing, my lord.
Where is your lease?
Lease, my lord, I have the successive purchaser.
Maybe. Where is your original lease?
Original, my lord, I have annexed the ROR, my lord. Annexure 3 and 4, my lord.
We are asking for the...
No, yes, well, I have not the documents, my lord, lease documents, my lord. But if your lordship can have a glance to page 30, the remark column, my lord. Your lordship got it. Page 30, my lord. Remark column, Odia Nothi number, Soy Ekanabo, Ekosteri, Hukum Mutalo, Dakal Karasanga, 245, Dakal Karat case number 4659 हुकुम मुताबिक प्लॉट नंबर 1460 समदरु एकर 0.50 जमा 0 पथकर 0.05 खाता रे दाखल खारज केस नंबर रे मतलब एटा सुरेंद्र पंडा को नारे ए केस ए लैंड टा
आपण काहाटू किनिले
मु किनली आगे बलदेव सिंह टू
बलदेव सिंह माने जोटा होची
अनेक्सर 4 माइल
एलडीटा तो आपण अनेक्सर 2 ना
माइल अनेक्सर 2 टा
राइट
आगे
तो से बलदेव सिंह तो ओरिजिनल
नो ओरिजिनल लेसिंग
पुनी काटू पाइले
से सुरेंद्र पंडा टू किन अनेक्सर 3 रे
तो कौन खाली लिखा है जी खारज हला ये हला सेला
ओरिजिनल से जो म्यूटेशन प्लॉट गुडा सब प्लॉट है जी सब है कि भी
and you have also been allowed an opportunity to appear it before the appellate authority
2013 में मतलब in a मतलब batch of cases my lord all the and in similar matters my lord this honorable court was also pleased to
we are aware of but here you can move in appeal
my lord since no opportunity of hearing natural justice violation my lord
just
for that appeal can be
come to that order which you are challenging
page 13
page 13
my lord well it has been come from the beginning well case record is put up to be on verification of record it is observed that the suit language recorded in favor of government as per the ROR published during the last settlement operation during the Khanpuri stage of ongoing settlement operation the OP of the suit case managed to record the suit hall plot number in her favor as per the lease granted to him or his vendor. But the trace map attached to the lease case record was not examined to know whether the land possessed by the OP has actually been leased out.
Yes.
It has been come to notice that a lot of irregularity have been made in the Tahsil level in different cases. Recently, a lease case was come to the notice of government, which was sanctioned in the year 1966 but the form used for the purpose was printed out in government press in the year 1969. The Honorable Court, High Court of Orissa, in their order dated 21 to 96 in OJC number 9449 of 93 also observed that the irregularity have been done in respect of leases case in the Bhubaneswar Tahsil level and directed the state government to inquire into the lease cases by an officer in the rank of secretary. In present case, no party has filed any documents to prove that the lease case in respect of the suit plot has been scrutinized. Hence, the court thought it proper not to record the government land in favor of private individual. The affected parties have scope to appeal before the appellate authority to prove the genuineness of their claims. Hence, the suo motu case is allowed.
So you mean to
No, we are not participated in the matter.
No.
He has matter. They have only noticed the that Surendra Panda matter.
रेंट केस जो 7 जोटा इंस्टीट्यूट
आगे
ହେଲା
हां सेतरे केवल
कोनको नोटिस जाइनी
No, Surendra Panda, your lordship, kindly have page 12.
Because you are not in picture, Surendra Panda is having the ROR. That is why Surendra Panda has been noticed.
Thereafter, my lord, they have Surendra Panda has sold the land to Baldev Singh.
But how the authority can come to know that you have been?
Yeah, Annexure 4, my lord, ROR in favor of the that Baldev Singh. ROR in favor of the Baldev Singh.
Then why are you showing Surendra Panda right now?
Surendra notice was issued to Surendra Panda only.
No, it's all right, but Baldev Singh is also not coming forward.
Yes.
Yeah, Baldev Singh has sold the land to me, my lord. Baldev Singh has already sold the land, my lord. I am in possession, my lord. Thereafter,
the question that has been
my
put
lord,
by brother,
my lord.
how the authority would know that if the land is leased out to Mr. X, X in the meantime has sold it to Y,
My
Y
lord.
has sold it to Z,
My lord,
you are the Z.
yes,
So
my lord.
how the authority would come to know that you have now purchased that land so that notice will be issued to you?
My lord, once a land is sold, my lord, registered sale deed must the record in the record must be to be reflected, my lord.
Where? Who will report it? Who
That
will report it?
Register.
You or the suo motu?
No, so much, my lord.
Then- Did you go for the mutation?
But thereafter, my lord, there is a dispute arises in respect to all the
That is why.
areas of Sampur, my lord.
Then how do
For that reason, my lord, that
registration habo गोटे जगह रे
my lord.
ROR इश्यू करिवे आउ जणे
Yes, my lord.
तो सेठी की तांकर नॉलेज रे जदी नाही ये authority,
Again.
so how they will come to know that in the meantime twice this land has been sold, so that notice you are taking a plea of violation of principle of
Natural justice,
right?
my lord.
So for that you have to show that the authority was aware
Yes.
that you have purchased the land, and in spite of that they are not issuing notice and they are not allowing so
But at least, my lord, they have to notice the Baldev Singh from which source he may intimate.
But he is not challenging.
He is
Baldev
not
is not
challenging.
challenging.
He has sold all the land, my lord. He has also not noticed.
So what? Unless
also
he
not
challenges,
noticed.
how can you can simply step into the shoe of your vendor?
I am. This is a registered sale deed, man.
but that alternative remedy is available
Yes,
to
yes.
you.
My lord, 2000.
Appellate
For that, though alternative remedy is available, my lord. Since, my lord, in the batch of cases and cases, my lord, this honorable court, my lord, and
What has been done in that batch?
my lord, opportunity of hearing ଦେଇକି ଆଉ ଥରେ rehear କରିବାକୁ order କରୁଛନ୍ତି.
Yes, sir.
ଆଜ୍ଞା ଆଉ ଥରେ notice କରିବେ affected party.
Yes, ସେ ଯୋଉ
ହଁ
ନରୋତ୍ତମ
ରଥ କେସ୍ ରେ ଆଉ in the batch of cases, my lord, ହେଇଛି ସେଇ ସେମିତିଆ order ହଉଛି. ସେଇ 13 ମସିହାରେ ସବୁ
so who is to now hear this matter?
ଏସୁ କାହିଁ ଶୁଣିବ? ଏସୁ କଣ ତାର ଇଏରେ ଅଛି?
ଏସବୁ କେମିତି କଣ ଏଇଗୁଡ଼ା decide
ସେଟା
ବୁଝିଲେ ଆପଣ ପରା ସେଟଲ କରିବା ବୋଲି କହୁଛନ୍ତି ଆପଣ ନାଁରେ?
ହଁ ସିଏ ହିଁ notice କରିକି କରିଛନ୍ତି ନା.
No, so motor has been initiated for a different purpose.
ଆଉ ସେଟା
On the
Irregularity.
government
ହଁ
ଦେଇଥିଲା
on the basis of this honorable court order.
just a minute government lease ଦେଇଥିଲା
ଆଜ୍ଞା.
Mr. X କୁ से लीज रो टर्म्स एंड कंडीशन कौन थिबो
आगे
लीज रे मन कर थिबो जे एई जमी आपण काहाकू बिकी परिबे नाही एई पर्पस पई यूज करिवे आपण कर जे वेंडर रो वेंडर तो सीए मन कर ताको डेविएट करते एगुडा किए डिसाइड करबो एसो केमती करता
से कैंसिल कर दीजनी सब तो असिस्टेंट सेटलमेंट से सेटलमेंट ऑफिसर आगे से हेबे लीज कैंसिल से ही करिसोनी सोमोटो कैंसिल विदाउट नोटिस your lordship may direct the petitioner to approach with all documents my lord.
We are we can say we has to approach the appropriate authority.
Yes.
Now we can not say
My lord, this type of order your lordship may kind of have a glance to my lord.
But uniformity order रे आपण कहउछन
2013 ने my lord
aspect
2013 ने my lord सेही सेमतिया सब ऑर्डर है एटा ना तुम लोग तो
the petitioner yes Mr. Nayak
there is an order of the courted bench.
The petitioner Girish Mahapatra has filed this writ petition challenging the order এটা ডেট কেবে 19/7/2013 ଆପଣ କଣ କରୁଥିଲେ 11-12 ବର୍ଷ
ଏଇ ନରୋତ୍ତମ ରଥ ପରେ ଆଜ୍ଞା ସେ ସବୁ ସେଇଗୁଡା ସବୁ ସେଇ ସେମ୍ ମୌଜାର ଦିଟା ମୌଜାର ଇନଷ୍ଟଲ ହେଇକି ଥିଲା
challenging the dated 19/7/2013 by Annexure 1 passed in rent case number 7169 of 2013. Refusing to record the government land in favor of the private individual. However, observation has been given by the Assistant Settlement Officer, Rental Colony Bhubaneswar, opposite party number 5, that the affected parties have spoke to appeal before the appellate authority to prove the genuineness of their claims. And accordingly, the suo motu case was allowed. So, the Land Counsel for the petitioner submitted that the petitioner purchased the land in question from one Baldev Singh by way of a registered sale deed dated 20/2/2008, and the sale deed by Annexure 2, and the record of right indicates that Baldev Singh, it has been recorded in the name of Baldev Singh, wide Annexure 4, the copy of the order was filed as Annexure 4. It is argued that neither notice has been issued to Baldev Singh nor to the petitioner, and therefore the impugned order suffers from violation of principle of natural justice, and the petitioner may be given an opportunity to appear before the concerned authority to have his say in the matter, and let the authority adjudicate the matter afresh. In support of his contention, he drew the attention of this court to a batch of cases disposed of by this court in Narottam Rath versus State of Odisha and another WPC number 1608 of 2018. 2014, so the copy of the order passed also in identical case in WPC number 9416 of 2014 bracket like Charulata De alias Kabi versus State of Odisha and others has been filed, which is taken on record. In the Norottam Ross versus State of Odisha, the impugned order of the Assistant Settlement Officer was set aside with the following direction. It a quote further. It is up to the petitioner to approach the appropriate authority to give him an opportunity of hearing, and if they do so, the concerned authority shall hear the matter afresh and decide. It is made clear that we have not expressed any opinion on the matter. Authority shall dispose of the same in accordance with law. The writ petition is disposed of accordingly.
Item 8. May I please, Your Lordship? Your Lordship, I am challenging the order dated 16/2/2024 passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, Your Lordship, wherein the prayer of the petitioner challenging the punishment order passed by the disciplinary authority as well as the confirming order passed by the appellate authority has been dismissed, Your Lordship. Your Lordship, the brief fact of the case is that the petitioner, while working as a sub postmaster, was served with a charge sheet containing 5 imputation of charges, Your Lordship. Your Lordship, the charges were that the remittance of the cash was remitted 1 day after it was received by the petitioner, Your Lordship. Therefore, alleging misappropriation, a shockingly disproportionate punishment of removal from service was passed by the disciplinary
What
authority.
amount you received and did not deposit on the same day?
Same day.
No, what is the amount in question?
Your Lordship, they have
50,000.
50,000, Your Lordship. And
No, but did it happen only once or
no, Your Lordship,
on
there-
several occasions?
Yes, 3 occasions, Your Lordship.
More than 1 lakh rupees papers.
Your Lordship, there was no pecuniary loss, Your Lordship, and especially in a case where Lordship, where the petitioner has given a detailed representation stating that in every case the amount was received in the evening, Your Lordship, and due to lack of leather bag carrying the cash, the same was not remitted on the same day. Rather, it was remitted on the next day, informing the higher authorities, Your Lordship.
Please come to the operative portion, paragraph 12 of the impugned judgment or order which you are challenging. Page 84 of the running and internal page is 15.
Yes, Your Lordship.
Paragraph number 12. Why are you not using that Vakam? Why it is there? Please read out paragraph number 12. Page 84, internal page is 15. Are you facing any difficulty? Mr. Naik, please help.
No, she knows everything, but
Paragraph 12, Your Lordship.
Okay, please come to paragraph number 12, the conclusion part.
Yes, Your Lordship. On careful consideration of the entire
Please adjust the mic, madam.
On careful consideration of the entire case of the applicant, vis-a-vis the reply of the respondents as well as the documents placed in support of the respective parties, this tribunal do not find any case of procedural lapses on the part of the respondents. Rather, disciplinary authority, after giving all reasonable opportunity to the applicant and following due process of rules, have passed the order of punishment, which has been upheld by the appellate authority in a well-reasoned order. The contention of the applicant that there was no pecuniary loss to the government and hence he may be exonerated from the charges cannot be justified when the dereliction and non-devotion to duty has been proved by the inquiry officer in its report. It is also not the case of the applicant that the charge sheet or punishment was imposed by an incompetent authority. No violation of principles of natural justice has also been established. A public servant is expected to be in his best behavior at all times and upheld the faith of the general public at large by his act and conduct. The misconduct of the applicant tarnished the image of the department before general public in large. Therefore, this court is of the considered opinion that the punishment of removal from service cannot be said to be disproportionate to the allegations made against the applicant, and it is held that it is not shocking to the conscience of this court. Accordingly, this tribunal does not find any illegality on the part of the respondents.
What is your submission?
Your Lordship, my submission is that the allegation time and again was that there was a misappropriation of the amount, Your Lordship. However, there was no pecuniary loss, and neither the applicant had submitted the amount after being charged, Your Lordship. He had immediately submitted the next day. Neither there was any intention to misappropriate the amount, nor there is any pecuniary loss caused to the government, Your Lordship.
My intention is your conduct. If I take the money from the public and keep it with me for 5 days, and I will again deposit it, I can't even keep it for a day without the approval of the authority.
Obliged, Your Lordship.
The ground that you are taking, that there was no leather bag to carry it,
Yes, Your Lordship. Those have not been
how
considered.
was it happening earlier to you and subsequent to you?
And
Is
even
it the
on
same manner?
Next day also, you must have deposited carrying the same in a leather bag or not. So the non-availability of the leather bag cannot be a ground not to deposit. And this has happened for the third time. Is every time you deposit it on the next day, or I sometimes
No, usually one next day, the first day.
in each case 1 day after.
Yes, Your Lordship.
Okay, how do you say that it is disproportionate? And if it is disproportionate, then the court has power to interfere it with.
Yes,
Have
Your
you got
Lordship.
any citation to that effect?
Your Lordship, I do not have a copy, Your Lordship, of the citations.
No, why have
I
you not
can
brought the
assist you.
decision? Whether there is any scope of the tribunal, for the scope of the tribunal to interfere if the tribunal finds that everything is okay, but the punishment that has been given is quite disproportionate to the allegation, then in that case also that can be modified. So there are decisions, I think.
Yes, Your Lordship. When the punishment is strikingly disproportionate.
So why have you not brought the decision? You get tomorrow. We are keeping it. Okay.
Obliged, Your Lordship.
Tomorrow may not be possible because it's a so it will be listed on Monday or Tuesday, whatever you like. We bring those decisions. Let us see how far you are prepared.
Obliged, Your Lordship.
Manas, another point is there, just a minute, other side also examine. Revision lies against the appeal. So that part also can satisfy.
Revision against what?
To whom it lies?
Against your appellate authority.
Against the appellate authority.
That he bypassed and say he has come
to the tribunal directly. Yes, this is my point. So alternate remedies available.
No, after the way
That's
disposed
Cat's
of,
order. Yes.
that order he has challenged. So there is no problem that any third authority is there. So we
No, it's fine, but
we interfere. All right, let him her come with those decisions.
Yes.
The petitioner, Dhaneshwar Soren, has filed this writ petition challenging the order dated 16/2/2024 passed by the London Central Administrative Tribunal, Cuttack Bench Cutters, in OA number 435 of 2021, in which the London Tribunal has been pleased to dismiss the original application. As it appears, in the while the petitioner was discharging his duty as SPM Bahalda SO, in account with Rairangpur headquarters from 15/4/2016 to 13/10/2016, he was charged with allegation of involvement of fraud case causing misappropriation of sum of rupees 1,15,913. Charge sheet was placed, consisting of 5 articles of charges, which was issued to him, and the petitioner, the inquiry was initiated by the inquiring officer, and the finding was given against the petitioner, and basing on which the superintendent of post offices, Moorgan's division, removed the petitioner from service. The petitioner preferred an appeal against the dismissal order before the Director of Postal Service, S.Q. Region, Bhubaneswar, which was also dismissed, against which the original application was filed. Stop. The London Tribunal, after considering the submission raised by the London Council for the respective parties, and after going through the orders passed by the disciplinary authority as well as the appellate authority, was of the view that since there is no violation of principle of natural justice, and the misconduct of the applicant tarnished the image of the department before the general public, the punishment of removal from service is not disproportionate to the allegation made against the petitioner. The London Council for the petitioner urged that the public money which the petitioner has received would not be deposited on the same day, but it was deposited on the very next day. And there was no question of any misappropriation by the petitioner. And
other charges are also there.
Huh?
Other charges are also there. He did not open the passbook, keeping the money for several days.
And the punishment which has been imposed by the authority is quite disproportionate to the allegation, and she wants to cite some decisions on this point. Put up this matter on 26th of November 2024. Yes.
Please, Your Lordship.
Our appearance may be noted.
Mr. Party, along with
D. Guchayat. Deepak Guchayat.
Deepak Guchayat.
Item 9.
The OGSL matter, my lord. The annex is pending, my lord.
Yung Ranu. Disposed of.
Item 10.
May I please, Your Lordship? Your Lordship, I am filing an additional affidavit of the orders passed in WPC number 1588 or 6 of 2000. Your Lordship, I did not file it in the counter, otherwise it would not have reflected today.
He wants to place it before the court because it would not have come otherwise.
Okay.
Justice Gawai.
Sorry, Your Lordship.
Justice Gawai's judgment.
No, Lordship.
So the recent one that you have seen in 2024, May.
Yes, Your Lordship. In the last yesterday that I cited, the judgment was of this court itself.
No, that is different.
Yes, Your
That is
Lordship.
different.
Please come to the order which we passed yesterday. 2011 टी बाहर कर दो मिस्टर नायक. 2011-2020.
Event is more with it.
ଏପଟରେ କ'ଣ ପ୍ରୋବ୍ଲେମ ହଉଛି କି ମିଷ୍ଟର ମହାନ୍ତି? ଏପଟେ କିଛି ପ୍ରୋବ୍ଲେମ ଅଛି କି?
While heard Mr. Soumyajyoti Biswal, learned counsel for the petitioner, while trying to explain the delay in approaching this court by filing this writ application, in paragraph number 6 of the writ petition, the averments have been taken that the petitioner was always kept in the dark and was never informed regarding any action taken by the opposite parties number 1 and 2. She urged that when the opposite party bank filed a writ application bearing WPC number 15886 of 2019 before this court with similar prayers, the petitioner never received any notice in the said case. And it was only brought to the knowledge of the petitioner when he wrote a letter demanding for answers, and the opposite party number 2 replied to the said letter, wherein the petitioner came to know about the existence of the said case. The learned counsel for the petitioner submitted that the said writ petition has already been disposed of and the matter may be taken up tomorrow to enable him to file the copy of the order.
Okay. So Hariji,
Your Lordship, that is the additional affidavit. I have filed the copies of all the orders that was passed in the said case.
you are not a party in the
No,
Your Lordship,
it was not a
made
party.
the party, we were opposite party number 5. But
notice, not
notice was never received, Your Lordship.
Not made a party nor notice.
say that it was made a party, the opposite party number 5 portion.
You have been made a party,
Yes, Your Lordship. We checked in the High Court website.
but notice was not received.
Notice was not received, Your Lordship.
What have you stated in your additional affidavit which you filed today?
Yes, Your Lordship. Your Lordship, I have stated that the additional affidavit may be read as part and parcel of the WPC. That is the first averment. The second averment is that it is imperative to mention here that the present petitioner is seeking relief on the ground of violation of natural justice. That is neither receiving any notice regarding the pending case nor being given an opportunity of being heard. In order to substantiate the averments or the submissions that has been made by the council, the following documents has been filed.
It was taken to record yesterday. This one. This one.
This one. Okay. This writ petition has been filed by Messrs. Sri Bimal Oxygen and Minerals Private Limited, represented through the director, Sri Bimal Kumar Agrawal, challenging the order dated 1/2/2017 passed by the Learned DRT Cutter in SA number 68 of 2015 by annexure 4. So also the order dated 24/7/2019 passed by the London DRT in MA number 389 of 2015 by annexure 6. एक केस में जो previous order को
It is the previous order. Yesterday's order.
stop. It appears that the petitioner was the auction purchaser and the sale certificate was issued in his favor on 21/12/2015. Messrs. Orissa Concrete Products filed SA number 68 of 2015 before the London DRT Cuttack Bench Cuttack against the bank, challenging the sale notice dated 24/11/2015. So also the possession notice dated 16/3/2015. And the London Tribunal had order dated 1/2/2017 has been pleased to allow the SA and quash the notices issued under section 13(2) and 13(4) of the Surface Act 2002. The bank filed MA number 389 of 2017 for recalling the order dated 1/2/2017, which was also dismissed by order dated 24/7/2009. The contention of the Land Council for the petitioner is that the petitioner is a necessary party since the sale certificate has been issued in his favor much prior to the adjudication of the case by the London Tribunal, but neither he has been arrayed as a party to the proceeding nor given opportunity of hearing. And therefore, the impugned order passed by the London Tribunal suffers from violation of principle of natural justice. The London Council for the petitioner submitted that even the matter was before this court in WPC number 15886 of 2019, which was filed by the bank challenging the order passed by the London BRT. And ultimately, the writ petition was dismissed. But in the said writ petition, though the petitioner was the opposite party number 5, but no notice has been issued to the opposite party number 5. So to the petitioner hyphen opposite party number 5. Land Council submits that though against the impugned orders passed by the London DRT in SA number 68 of 2015 and MA number 389 of 2017, there is a appeal provision under section 18 of the Surface Act to the appellate tribunal but the petitioner cannot approach the DRAT since it is barred by limitation, and the appellate tribunal has no authority to condone the delay in filing the appeal, and the matter is sub judice before the Honorable Supreme Court. Your Honor, tell you the your Honor, order pass through. In case of branch manager urban cooperative bank limited, Cuttack versus registered debt recovery tribunal and another, passed in WPC number 8100 of 2019, which was disposed of on 12/5/2021, it has been held that neither section 17(1) of the Surface Act nor section 31 of the RDB Act permits the DRT to condone the delay in filing an application beyond the prescribed period, and therefore the DRT was error in condoning the delay and allowing the opposite party number 2 to proceed with the appeal filed before it. In case of Bank of Baroda and another versus Messrs. Parasadial, Tulsiram, Prashadilal, Tulsiram, Sidgard Private Limited and others reported in 2022 SCC Online 1006. The Honorable Supreme Court held that the reason for providing a time limit for 45 days for filing an application under Section 17 can easily be inferred for the purpose and object of the enactment. The Honorable Supreme Court took into account the decision in the case of Transcore versus Union of India and another reported in 2008 1 Supreme Court cases 1 to 5, wherein it has been held that the Surface Act is enacted for quick enforcement of the security. As it appears that the in the case of KG Judge and another versus Authorized Officer Indian Bank, passed in SLP Civil number 4754 of 2021, which is of sub judice before the Honorable Supreme Court. A similar point has been raised. Stop. Considering the submission made by the learned counsel for the petitioner that he is the auction purchaser and he has not been made a party before the learned DRT either in SA number 68 of 2015 or in MA number 389 of 2015, and the orders were passed which directly affect the petitioner, and in WPC number 15886 of 2019, though the petitioner was made a party, but no notice has been issued to him. and the fact that the period prescribed for approaching the appellate tribunal under section 18 of the Surface Act is already over, and whether the DRAT has got power to condone the delay in filing the appeal is sub judice before the Honorable Supreme Court. We are of the view that this court has to examine in this writ petition as to whether the order passed by the learned DRT dated 1/2/2017 in essay number 68 of 2015 and order dated 24/7/2019 in MA number 389 of 2015 sustainable in the eye of law or not, or it suffers from violation of principle of natural justice. Issue notice on the to the opposite party on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to the opposite party number
4.
No, 3 also. Why notice is to go to the register debt recovery tribunal. So 3, 4, no notice to be issued, and also 6. Why are you impeding debt recovery tribunal as a party? He has passed the order. You are challenging the. Is it necessary that the debt recovery tribunal should be made and the register of the DRT?
Lordship for number and question.
3, 4, and 6. There is no notice be issued. You have already entered appearance. Somebody has entered appearance for the. Nobody has entered. Requisites for issuance of notice. Mr. Naik, is there any counsel for Urban Cooperative Bank?
My lord, I'll find out, my lord. I'm not aware. They have their own panel, my lord.
আসি panel কথা কইলো আচ্ছা ঠিক আছে কাগজ দেবে ঠিক আছে issue notice so and so requisites for issuance of notice opposite party number 1 2 and 5 filed by within a week कर दियो list this matter in the week commencing second week कर दियो ना second week of January 2025. Right. You are Soumya Jyoti Biswal.
Lordship, I am Shweta Senapati.
Not reflect is not. Okay. You give your name that is not reflected.
Yes, Senapati.
No, the name which has been
in our order sheet.
She has argued the matter,
Yes.
but the name of Soumya Jyoti Biswal has been reflected. So her name should be reflected.
In the order, the name of S. Senapati be reflected.
No, you have argued the matter well. That's the good point, right? So be patient and suppose you feel that the judge is putting some question, don't feel that they are against you. The judge wants that some kind of clarification and also see that how you are preparing the case. So don't lose your heart, be enthusiastic, prepare the case and praise the matter. Okay?
Yes, sir.
Yes. So far as the condonation power of the appellate tribunal under section 18 has already been decided by the
where it has been decided. No, but they have shown that this is the case.
So far, section 17 is concerned, that is sub judice in the case of Karnataka High Court coming before the Honorable Supreme Court.
18 is already disposed of. What is the result?
But the so far Baleshwar Dayal case is concerned, already decided, and section the power vested with the DRAT appellate tribunal to condone the deal.
Where is that?
Where is that?
2015 সেটা হয়ে যাচ্ছে
2015
2000 বালেশ্বর দয়াল কেস না
No.
সেটা অলরেডি ହେଇ ସାରିଛି ଆପଣ ଦେଇଦେବେ ସେଟା
No, it's all right. Please give his reason. We have already, so it is to come.
ସେଟା ସେ କେବଳ ସେକ୍ସନ 17 ରେ ନାହିଁ ବୋଲି ସେଟା
No, no, 18 भी अच्छी सीट
No,
है।
the why
18 is also there.
18 ରେ already decide ହେଇ ସାରି settle ହେଇ ସାରିଛି
no, recently it has been, this matter is of the year 2021 re refer ହେଇଛି
18, section 18.
ତେଣୁ maybe that they have discussed.
urban banks
No,
No. जी नहीं नहीं
the ଏବେ ଯୋଉ case ଟା ହେଇଛି ଆମେ କହୁଛୁ ସେଟା ହଉଛି KJ Judge and another versus authorized officer Indian Bank.
that is the High Court judgment.
You see, question is that, just a minute, learning council, it's the same thing. The purpose, why they have stated that what is the purpose for which this DRT or DRT is functioning? What is the object for this? Earlier, the matter was challenged before the High Court. Now, why they have opened up a tribunal? The purpose is for early disposal. And that is, please listen to us since you have raised this point. So when they are fixing the time limit that it is to be made within 45 days and this appeal is to be made within 30 days. So the purpose behind is that as quick as possible, this should be done. So the question is that when a specific period has been prescribed and the purpose is something there, so whether any this delay can be condoned or not. So when that has been referred to that is pending in for section 17, same principle applies to appeal it also. Even if there is an earlier decision, they may revisit the case of that Rameswar Dayal case.
While notice was issued by the Honorable Appeals Court in itself the Judge case, the Honorable Appeals Court issued notice referring that when the limitation condonation power vested on section 18 and this the Honorable Appeals Court permitted to applicability of limitation act to section 18, why the same is not applicable for section 17? On this question, notice was issued. But
Only we'll see that.
but Baleshwar Dayal case already settled and that attend finally.
All right,
All right, then let them come with the counter. We'll see.
Another case of our High Court says limitation of act is applicable to section 17.
That's
C.DASH case.
No, that is under sub judice.
That is section 17 is sub judice.
Right. So no, you say that 18 has already been decided. So we want a copy of that judgment. Please give us. Okay. Or just you see the what is the citation that only also. हाँ नहीं copy भी दरकार नहीं अपन just गोटे slip रे अपन party ना एवं citation that will. Yes.
Item 11.
Much obliged, Your Lordship.
Yes.
Even my previous lordship, here the petitioner made to challenge the possession notice and sale notice millers in the annexure 2 and annexure 4.
Yes. Go to the alternative remedies there. Already disposed of. Yes, next.
Item 12.
Yes, item number 12.
Item number 12, Your Lordship, it is a covered matter related to disbursement of compensation after reference, Your Lordship.
Well, in this case, what happened? The land was acquired. Father of the petitioner got the compensation. In reference, came to the referral court. Referral court enhanced the amount. Challenging that order, state government came to before the Honorable Court. And here, in the year 2007, the appeal was dismissed. The petitioner thereafter has not communicated anything. My Lord may can direct the petitioner to give a detailed representation with the order of both the copies. And if there is no higher, any application is pending before the higher forum, then authority.
The
Your Lordship, actually, similarly situated persons.
Sanction and disburse the compensation amount pursuant to the order dated once. माने 10/12/2002 ର order ହେଲାଣି
order तापर ताऊ चैलेंज करी आथिला हाई कोर्ट को स्टेट गवर्नमेंट 2007 रे से केस डिस्पोज ऑफ हला डिसमिस हला अपील तापरे आउ स्टेट जाइछथि कि न जाइछथि फायर फोरम को इट इज कंप्लीटली साइलेंट अबाउट इन द रिट एप्लीकेशन गोटे लिटिल
inordinate delay होची but you submit a representation lekon
with all the copy of
all
both
right, the writ petition has been filed by the petitioner Ashwini Kumar Senapati,
son of the
recorded
owner,
son of late Ghasiram Senapati, who was the recorded
tenant of the land acquired.
The land acquired, challenging the with a prayer for non-disbursement of for a direction for disbursement of the compensation amount pursuant to the order dated 10/12/2002 passed by the Land and Civil Judge Senior Division Dharamgarh in MJC number 47 of 2001. The Land Council for the petitioner submits that against the said order, the state filed LAA number 212 of 2003 before this court and by order dated 20/12/2007, the writ petition was dismissed.
The land appeal.
The land acquisition appeal was dismissed and the award was confirmed. Award passed by the Land and Civil Judge Senior Division Dharamgarh in MJC number 47 of 2001, which was a reference under section 18 of the LA Act, was confirmed. The Land Council submits that in spite of such dismissal order way back in 2007, the authority has not yet disbursed the compensation amount. Mr. Naik, Land and Additional Government Advocate, submits that it is not known whether the order passed by this court in LA number so has been challenged in the higher forum or not, and if the petitioner may be asked to file a detailed representation with all the orders before the concerned authority so that it can be adjudicated at the earliest, and if the petitioner is entitled to get the compensation, then steps shall be taken in that respect. Considering the submission made by the Land Council for the respective parties, we dispose of this petition, giving liberty to the petitioner to file a detailed representation before the opposite party number 3, Special Land Acquisition Officer.
Yes.
He has to give the compensation.
Yes, Your Lordship. And opposite party number 1 and 2 need to sanction the.
That is it.
Opposite party number 3 within a period of how much time you require?
Well, opposite party number 4, Zonal Official LA 1 Upper Indravati. He filed the appeal. Zonal officer filed the appeal before this honorable.
No, it's all right. But now it is representation is to be made to this Special Land Acquisition Officer.
He's the disbursing authority.
So within
2 weeks.
2 weeks from today, with all the necessary documents and the orders passed, and if along with the copy of this order, so that the on receipt of which the opposite party number 3 shall take a decision on the representation within 3 months, and communicate the order to the petitioner within 2 weeks of the taking decision. If the personal hearing of the petitioner would be required, same shall be provided to him. Yes.
Item 13.
Here the petitioner had availed the loan of 16 lakhs for housing purpose. But in fact, challenging the notice of
the bank, a essay was filed, annexure 4, page 15. In the essay, the petitioner was directed to deposit 5 lakhs on or before 14/2/24, page 16. Your Lordship may kindly have it.
Yes,
Yeah.
on 14 and 21st.
Yes, he could not. He could not pay the money. But now, my lord, what has happened? They have given a position notice. My lord, I'm ready to comply that order, but because there was non-compliance,
Again,
now the bank is
same forum. File a phrase essay.
Physical position and CLD has since been executed.
Oh, it is shell certificate issued.
Yes, shell certificate issued and CLD has been executed since 21st September 24.
21st
September 9.
9, 2024. Shell deed has been executed. Okay. The Land and Council, the petitioner, the petitioner has filed this writ petition. Petitioner now, like the Anita Ranila, so and so has filed this so and so, challenging the later dated so and so, passed by so and so, like the Land Council for the petitioner submits that the petitioner is ready and willing to comply the order passed by the Land and Debt DRT Cutter dated 7/2/2024 to deposit the entire amount and necessary direction we issued. At this stage, the Land Council appearing for वकालत नामा फाइल कर ले submits on instruction that in the meantime the auction sale auction has become successful and sale certificate the sale deed has been executed on 21/9/2024 and physical
since 9/8/24
and physical position has been taken on 9/8/24 तापर it आगे physical position date आगे सेटा लिखिए तापर सेटा लिखिए है ना in view of so and so the submission place that case जो the decision of the Bopna Bapna case है ना and the petitioner has got alternative remedy disposed of. Yes, next man.
Item 14.
My lord, the father of the late father of the petitioners had taken loan, several credit facilities in the name of CORAM Stone Cluster, and subsequently the account was NP, and he also, the bank officers pressurized him, he committed suicide. And the petitioners also taken loan in the name of Sai.
It is again same thing. 13 for notice you are challenging.
My prayer is, my OTS application, they are not.
They take that order there. Here, like same order, alternative remedies available. 13 for notice challenge, disposed of. Yes, next.
Oh, please.
Item 15.
Petitioner is the daughter of the recorded tenant whose land has been acquired under the Railway Amendment Act, and the award has not been passed in his favor.
Award
has not been passed in her favor. Therefore, she made an application before the competent authority under Annexure 1 to for apportionment or to refer the dispute as per the provision section 28 subsection 4 of the Act. I am handing over the Act. Since this is under the Railway Amendment Act.
No, it's all right. This has been filed on 11/11/2024. Just a week back.
Because I am hurried, they are going to disburse the amount. Already,
no, what do you want now?
That may be disposed of as early as possible so that disbursement
can give some time. ଆପଣ 11 ତାରିଖରେ ଫାଇଲ କଲେ ରିଟ୍ ପିଟିସନ ଆଜି
ସେ disbursement ଟାକୁ process କରିବେ that is the
ଆପଣ ଯଦି objection raise କଲେ କଣ ଆପଣଙ୍କ objection ନ ଶୁଣି ସେମାନେ ଇ କରିଦେବେ
ସେମାନେ କରିଦଉଛନ୍ତି ଯେହେତୁ record of right does not reflect my name.
Who is appearing? You are appearing.
Union of
India.
Myself and my donor.
So let the authority consider this objection which has been filed in accordance with law. We are not expressing any opinion. Second, this writ petition has
He
been
has
filed.
annexed the annexure 4.
No,
that
his
is-
application is there under annexure
This
1,
one.
right? That is dated 11/11/2024. So the authority concerned has to take into account.
Yes.
So this writ petition has been filed by the petitioner Ichha Kumari Patel alias Chaudhary with a prayer for a direction to the competent authority hyphen deputy chief engineer, comma, Southeastern Railway Project bracket like the opposite party number 2 to take a decision on the application of the petitioner for apportionment of compensation amount and reference of dispute under section 20 bracketary H bracketary 3 and 4 of the Railway Amendment bracket N Act 2008. The Land Council for the petitioner submits that the petitioner has already preferred an objection before the
Competent authority.
Huh?
Competent authority shall
opposite party number 2.
2.
Opposite party number 2 on 11/11/2023 to keep in abeyance the process of providing compensation amounts to anybody else who have interest in Hal Khata number 14 Mauja Kushra Tahsil PSM district Sundargarh, but no order has yet been passed, and necessary direction be issued to the concerned authority to take into account the objection filed by the petitioner in accordance with law before taking a decision for disbursement of compensation amount. Land Council for the Central Government Council. Thanks for
DSJ and DSJ along with it.
Acha, so and so, they don't sleep it. Appears for so and so, and he has no serious objection to such prayer. Considering the submission made by the Land Council so and so, opposite party number 2 is directed to consider the objection filed by the petitioner under annexure 1 at the time of taking a decision on the disbursement of compensation. And it is made clear that we have not expressed any opinion on the merits of the objection filed by the petitioner before the opposite party number 2. Accordingly, the writ petition is disposed of. Yes,
Madam, that doesn't be the under official.
it is under official. We are just coming within 2 minutes. Yes.
Item 16.
My lordship. Well, I filed earlier I filed a consolidated cost title because of there is some mistake. Allow me a fresh cost title, man. Consolidated cost title.
So you gave some names.
Yes.
But you are not in your consolidated writ petition. The names are discrepant, so that has been pointed out.
Because there is a mistake. I just left out the name of the village, man.
You should have filed another
fresh application.
Fresh interim application. You have taken an order that these are the parties whom you are to who are to be substituted, right?
Yes, ma'am.
So therefore your consolidated writ petition cost title should be incorporating those names only.
My lord, may I submit?
So if something you have left it out or something.
Not in IA I've already mentioned, my lord, but in consolidated cost
Writ
title.
petition you have not mentioned. Consolidated writ cost title has not been filed in the writ.
Already filed, my lord. The address is correct, my lord. But in the consolidated cost title, I just missed the village name, my lord. So I only prior to file a fresh consolidated cost.
Yes. The land council for the petitioner takes some time to file a fresh consolidated cost title, right?
Yes, my lord.
What time you require?
1 week, my
lord. 1 week time.
And
put up this matter, put a date in the meantime.
And one more thing, my lord, I place to that unutilized requisite may be utilized, my lord.
Obviously.
Yes, obliged, my lord. Second item, the item 17 is also same, my lord. Similar, my lord.
So once you file that consolidated cost title,
Yes,
then the question of issuance of notice will arise,
Yes,
and
my lord.
your unutilized that would be utilized.
Yes.
So you filed it after filing of the consolidated cost title. The unutilized requisites that would be utilized for issuance of notice, right? Yes. Next, same order in.
Yes, my lord.
item
17
number
not same. Obliged, my lord.
Item number 18.
IA number so and counsel Mr. Das files a memo for withdrawal of the interim application. IA is disposed of.
Item 19.
May I please also? Lord, here, my lord, my prayer was, if Lordship kindly come to page 9. Land acquisition, compensation, and rehabilitation benefit. I have said that direct the opposite part number 3 to 40 consider the grievance of the petitioner, release the land acquisition compensation in her favor, and extend rehabilitation benefit in respect of 1.32 decimals of land. Amount is with them. Amount is with them. What has happened, madam?
Annexure 7.
Madam?
Annexure 7.
Annexure.
You have submitted a representation.
Yes, madam. Annexure 7.
But that is of 5/3/2014.
So when madam, the land acquisition proceeding was going on,
correct,
they issued me notice.
No, that is all right. But this Annexure 7 is of 2014.
Madam, that was madam I have given in terms of Annexure 6, madam, as a reply to Annexure 6. Page
True,
25.
but that is of that time.
No, what happened on your representation?
The matter is still pending, my lord. When the
Still pending.
disbursement has been stayed by the
All
Supreme.
right. Yeah.
What has happened, my lord, in the ROR, though my name was there,
Right.
but there were some enclosures name was also included.
All right.
So who is to take a decision on your
My decision, my lord, is to be taken by opposite party number 3.
All right.
So anyone is appearing for
My
Yes, sir, I'm
senior
appearing.
appeal.
any decision taken, Mr. Das?
No, the money has been deposited. The problem is the ROR shows some encroachers. Even after his correction in the second appeal, the latest shows there are other encroachers in the name appears in the ROR. So for that
No,
reason,
why don't you pass an order on this representation? It's dispose it of.
we will dispose it of.
Huh,
Because my stand is under the Coal Bearing Act, there is a provision, section 14 and 17, there is a designated court. One is at Dhenkanal, another is Sambalpur. We have said he can approach there.
So why don't you dispose it of?
Yes. Then the reason is that he said that the representation is.
In my counter, I have said that specifically. He can.
No, there is no rejection that it was
He
rejected.
said that this representation I have not got any reply from the authority. So just communicate that.
Your Lordship,
I think that is better.
Your Lordship,
We are
kindly
disposed
pass
of
that.
with that observation that let them
Yes.
communicate because the other forum is available.
Yes.
You can approach the who is that forum? Even in your counter affidavit.
Dhenkanal,
Court
Oh,
referred
this
court
district is in
Another is at Sambalpur. Another
is at Sambalpur. Huh?
Yes. So for this petition, my lord, in the event required to approach
Millers?
Who paragraph election?
Yes, sir. Paragraph 4, Millers, page 28 of the brief.
Paragraph
page 28, paragraph 4.
Yes, sir.
That the land has been acquired under the Coal Bearing Areas Acquisition and Development Act 57 under section 17 of the said act. Specifically stipulates that any dispute with regard to payment of question, compensation, title, etc. shall be dealt before the tribunal constituted under section 14 of this act. As such, the writ application has been filed under 226.
So you have to approach it to that.
Well, can you come to page 6? Unless there is an order, my lord, I cannot go.
All right.
Yes, well, can you see paragraph 6? Same next page, my lord. The ROR shows, my lord, the names of 3 encroachers. And it has been settled, my lord, in the second appeal.
No, in second appeal, thereafter, Miller's encroachers still appear.
We are not
to see
that.
Obliged.
This writ petition has been filed by the petitioner, Tulendri Pradhan, with a prayer for a direction to the opposite party number 3, Deputy Estate Manager, Ivy Valley Area, Mahanadi Coalfields, Gajraj Nagar, to consider the grievance of the petitioner forthwith and to release land acquisition compensation in her favor.
Just indicate 100% land has been acquired.
Just a minute. In respect of 1 acre 32 decimal of land as described in para 5. Para 5 means you read para 5. Say para 5 read petition detail ta diya hai. Critical election ଆଉ ବାକି ଯୋଉ ମୌଜା ପୂଜା ଗୁଡାକ ସେଠୁ
para 5 and 6
para 5 ହେଲା ତାପରେ ଆଉ ଗୋଟେ ଏଇଟାକୁ ଦେଖି ଲେଖିଦେବେ ହେଲା. The Land Council for the petitioner submitted that representation has been submitted before the opposite party number 3 way back in 2014 for release of land acquisition compensation in her favor, but she has not received any response from the concerned authority. Mr. S.D. Das, land senior advocate appearing for the opposite party, filed a counter affidavit of the senior manager so and so, wherein in paragraph number 4 it has been stated that the land has been acquired under Coal Bearing Areas Acquisition and Development Act 1957, bracketed CBA and A and D Act 1957. Section 17 of the said Act specifically stipulates that any dispute with regard to payment of compensation, title, etc., shall be dealt before the tribunal constituted under Section 14 of the Act, and therefore the writ petition is not maintainable. In paragraph number
11 minutes.
11,
I've said this tribunal is a Dhankana.
it has been stated that court election Dhankana stated that
the CBA tribunal.
The jurisdiction lies with CBA tribunal constituted under the said Act at Dhankana. The Land Council, when this court made a query to Mr. Das whether the representation filed by the petitioner way back in 2014 by Annexure 7 has been disposed of or not, he assures this court that orders shall be communicated on the representation to the petitioner within a period of 4 weeks from today, so that petitioner can seek appropriate remedy in accordance with law. Considering the submission made by the Land Council for the respective parties, this writ petition is disposed of. Observation that the opposite party number 3 shall consider the representation under Annexure 7 filed by the petitioner in accordance with law within a period of 2 weeks from today and communicate with order within 2 weeks of taking the decision. It is made clear that this court has not expressed any opinion on the merits of representation under Annexure 7.
Only one prayer, madam. There are two prayers. One is regarding compensation. The other matter, they have arbitrarily taken that 1 lakh 32 days. So, but the resettlement benefit matter, rehabilitation.
Yeah, that is part of it, no? That is part of it.
You should just indicate that, that they have to take a decision on that also.
No, representation you have not mentioned. You have mentioned.
You
Just indicate,
your prayer will quote in entirety, Allah?
Will.
Yes.
Well,
Item 20.
an urgent copy.
Yes.
Yes. My lords, the order number 11.
The order which was passed, manner staying disbursement. That may be taken up, manner that will be considered.
So we get to
But interim order was also passed. 12/3/2018.
Okay. Mr. Das, there is an interim order. We are passing the order that this order shall continue till the
disposal of
the interim order passed by this court that the compensation amount in respect of the acquired land in question shall not be dispersed if not already dispersed shall remain in force till the disposal of the representation under Annexure 7 by the opposite party number 3. Right? Urgent certified. Yes, Mr. Ratta.
My lords, order number 11 dated 12th of April 2023 may kindly be sent. I have filed my calculation.
I just received calculation. Yes, madam.
Yes.
I have already received in evidently that has not been filed.
No,
yourself, Your Lordship, we can.
In terms of the order dated 12/4/2023, Mr. John Kumar Roth, senior advocate, has filed the statement of financial benefit.
I'm entitled to.
The opposite party, Ramachandra Mahapatra, is entitled to for the period from 1/11/2010 to 31/10/2015, and the gratuity bracket approximately.
If the writ appellate is allowed.
Direction Yes. With the affidavit of the respondent. The copy of the affidavit along with the statement of financial benefit has been handed over to the Land and Central Government Council.
Appellant, my lord.
To the
Appellant, I am appellant.
appellant, who submits that in terms of the said order, he has also prepared a calculation sheet and is likely to file it within
10 days, madam.
Within 10 days, giving copy thereof to the Land and Council for the respondent. So, upon 10 days nebe, तांको सेठी verify करिवे. So, matter asu 16 तारीख दिन.
Madam.
Right? This matter in the week commencing from 16th December 2020.
Item 21.
Item 21, my lord. Your lordship, it's a state's appeal. Your lordship, from the noting, it reveals that no written note of argument was filed by the state. My lord, lordship may call this matter on coming Thursday. I shall file on it.
Written note of argument filed by
And AG not filed. Written note of argument. No.
We have not had it. This matter was heard before this bench, no?
My lord, this is about the persons, those who have been appointed by the university.
Correct.
Due process of selection, advertisement, etc.
But was it heard by this bench?
No.
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 State has filed the appeal.
Correct.
University
No,
has
it
not
was
filed
not
appeal.
heard. No.
It was never before this.
Before this bench.
So the last order that you had filed is only an adjournment was there.
Nice. For the first time, it comes to my
When
knowledge.
the matter came, adjournment was sought for, and accordingly that was granted. That's all. We have not heard this matter. So,
Should I call this matter
maybe that previously some order was passed that you file the written note of submission.
Yes, ma'am.
But it is well and good if you, this is a final disposal matter.
Yes.
You can file your written note of argument. There is no problem to that. You intend to, you want to take some time.
Yes, my lord.
So tell us a date so that it can be
on coming Thursday, my lord.
coming Thursday.
Yes.
So give a copy in advance to Mr.
To my
Roth.
yes, to me,
Right.
Mr. Purohit.
Purohit, you are appearing for whom?
University.
Also to the Land and Mr.
Yes.
Purohit, the Land and Council for the state submits that he intends to file a written note of argument by next Thursday, that is 28th of November 2024, giving copies to the Land Council for the respondents. Put up ताले आरो सप्ताह अपन देई दियंतु भितर जे 28 तारिख भितर देबे ताबले गोटे सप्ताह से माने देखंतु 9 तारिख आसु मैटर this matter in the week commencing from 9th of December 2024
for final disposal.
For final disposal.
Item 22.
In item 22, my lord, we have received the parawise comments, but no counter has been filed.
How much time you require?
About a week or two.
1 week.
1 week.
the Learned Counsel for the state submits that he has already received the para-wise comments and will prepare the counter affidavit within a week and serve it on the Learned Counsel for the petitioner. Put up this matter, ତାର ଗୋଟେ ସପ୍ତାହ ଭିତରେ ଦେବେ, ତାର 2 ସପ୍ତାହ ପରେ ପକେଇ ଦିଅନ୍ତୁ. Rejoinder affidavit, if any, to the counter affidavit can be filed in the meantime. Right?
I'm about the OP number 2, 4, and 7. I have already filed counter.
They have filed counter. The Land Council for the opposite party number 2,
4, 7.
2, 4, and 7 submits that he has already filed the counter affidavit. All right. Yes. And that we'll fix that. ଗୋଟେ ସପ୍ତାହ ତାଙ୍କୁ ଆପଣଙ୍କୁ ରିଜାଇଣ୍ଡର 2 ସପ୍ତାହ
ଗୋଟେ ସପ୍ତାହ ଦେଲେ
ହେଇଯିବ. ଆଚ୍ଛା
ମତେ ଗୋଟେ ସପ୍ତାହ ଦେଲେ କରିଦେବି.
ଠିକ ଅଛି. then 16th ରେ ଆସୁ.
Yes, ma'am. Okay.
Item 23.
23 are for opposite parties.
Who is for the petitioner?
So Niranjan Panda was appealing.
Pass over করছো
In person.
এটা in person
Manoranjita Behra and another.
council ଦେଇଛନ୍ତି ନା
Represented by
ନିରଞ୍ଜନ ପଣ୍ଡା.
ଅଛି. ଆମ order in person ଲେଖା.
ଆଚ୍ଛା in person ଅଛି. ମନୋରଞ୍ଜିତା ବେହେରା.
No, thereafter yes. In person ଅଛି ସବୁବେଳେ. And Mr. Niranjan Panda is also there.
His power is.
His name is there. Mr. Niranjan Panda.
Can we pass over the matter?
You are in person, no?
Actually, I have counsel. I've engaged the counsel. So kindly pass over. It can be heard in 2 o'clock.
It's all right. We are not passing any order today so that it will come next week. Right?
My lordship, next week it will not reach, my lordship.
Yes.
Next week it cannot be reached, my lordship. Already 2 weeks have already gone, my lordship. Last means after the list, completion of list can be taken.
No.
Second up, my lordship.
Madam, after lunch there is a separate list.
Bench, no?
This criminal matters are taken out.
My
So
lordship.
today we are now this is a final disposal matter.
My
And
lordship.
your counsel is not there. So what you want? That we will not take up other matters. We will wait for your counsel to arrive and make a submission.
My lordship, after 5 minutes, my lordship, in another
We do not know because once we start another matter, we do not know how much time it will take. So that is why we are not now passing any order. We are just keeping as such. All right. Yes. For the next matter.
Okay.
Item 24.
19 writ petitions were filed by the state. It is one of them. And this honorable court has dismissed one of the writ petition on the ground of delay. Because it was.
What about the other writ petition?
The other writ petitions has not come. My writ petition, the identical matter has been dismissed. Because the order was challenged after 24 years after.
Please verify it.
My lord.
So that and give us the
Yes, my lord. I have just.
No, the other writ petition number so that it can come along with all those writs and it can be all the orders can be.
Well, I am appearing in 2 writ petitions. Other councils are appearing.
No, so that you say that there are 19 writ petitions.
19 writ petitions.
One has been disposed of. That means 18 are pending.
One has been disposed of. And
which order you are?
That is dismissed
Which
on
order
the ground of delay.
Which order you are just pass on that order?
It's on the ground of limitation. That
Limitation it has been dismissed. Because it is challenged after 24 years after. They peculiarly
is in the year 2003.
That is 2003. In our case, in 1998.
Oh.
Reliable Surma Manjari case, it has been also upheld by the Supreme Court.
Let me verify, my lord.
I am also.
Let me verify.
It is record.
Just verify. We are just asking the state also to provide the connected case number.
Yes,
yes,
because we are recording his submission that other similar cases are pending. You are to just.
Yes, I will do that.
Okay. This is item number 24, WTC number 3112 of 2022. Mr. Nirod Kumar Sahu, Land Council, appearing for the opposite party, submits that identical matter has been disposed of by this court in WPC number 8138 of 2022, by order dated 12/3/2024, and on the ground of limitation, the writ petition filed by the state has been dismissed. The Land Council produces the copy of the order, which is taken on record. The A copy has already been served on the Land Council for the state. Stop. Mr. Sahu submits that he has instruction that as many as 19 writ petitions have been filed. Similar writ petitions have been filed, and only one has been disposed of. That is WPC number 8138 of 2022. Let the Land Council for the state furnish the case numbers of the other writ petition, pending writ petition, to the court master, so that this can be listed along with this. Next week it can be listed.
Yes, next week.
Okay.
Another matter also number here. If you my lordship desire, then
I can give.
lordship.
Land Council for this one, so Mr. Sahu furnish the case number for
I'm giving.
This is to be listed along with the number for. তাছাড়া বাকি ওটাকে সে ফার্নিশ করিবে খালি এর করে ছেড়ে দিবে লিস্টটা দেবে তারপরে এরকম কতটা ইনসার্ট হবে yes কি অবস্থা রকম
Item 25.
May I please your lordship? I am appearing through virtual court Kalahandi.
Yes.
Your lordship, the petitioner is presently the bench clerk grade 1 of the Learned Court of Additional District of Bhavani Patna. He has challenged the impugned order dated 28 January 2022, passed by the opposite party number 2 and marked as Annexure 7, page number 34 to 38, your lordship, rejecting the claim of the petitioner for the promotion to the rank of Chief Administrative Officer, your lordship. The opposite party 3, who is the junior to the petitioner, was promoted to the rank of CAO, and for this, being aggrieved by the same, the petitioner had filed a writ petition number 29710 of 2021, your lordship, annexure 5, page number 33, which was disposed of with a direction to the opposite party number 2 to pass the reasoned order by 1st February 2022.
Yes.
Accordingly, on 28th January 2022, the opposite party number 2 rejected the representation of the petitioner, and hence this writ petition was filed, your lordship.
So did you proceed in the committee, appeal committee?
There is an appeal committee. So this order is appealable. So have you availed that, or you are not aware about it?
No, your lordship, we did not proceed with the appellate committee. Rather, by virtue of the order passed by this honorable court
since an alternative remedy is available, you can approach this court before the appeal committee. So we are giving you liberty and approach this court, file an appeal so that it can be adjudicated by the appeal committee, right?
Yes,
The
yes.
writ petition has been filed by the petitioner, who is presently working as head clerk in the office of SDGM Dharamgarh.
Your lordship, ADJ Bhavani Patna.
Achha, now he is working as
now he is
who was working like that? Who was working as SDGM in the office of SDGM Dharmagarh in the district of Kalahandi, and at present working in the
as the bench clerk grade 1 learned court.
Just a minute, as a bench clerk grade 1
learned court of additional district judge Bhavani Patna.
Additional district judge Bhavani Patna has filed this writ petition challenging the order dated 28/1/2022, passed by the Lenin. কি অর্ডারটা পাস করে
এটা কি ডিস্ট্রিক্ট জাজ না সিভিল কি করছিস
Your Lordship, Registrar.
কমিটি
No, Your Lordship, Registrar of the Civil Court, Bhawanipatna.
Registered Civil Courts, Kalahandi at Bhawanipatna. In disposing of the representation filed by the petitioner, observing that though the petitioner is senior to opposite party number 3, Ramesh Chandra Sahu, but as per Rule 11, of Rule 11 of Odisha District and Subordinate Courts Non-Judicial Staff Services method of recruitment and condition of service rules 2008, promotion to the higher post is to be made on the basis of merit and suitability with due regard to the seniority. And the DPC, after considering the merit and suitability, has made opposite party number 3 eligible for promotion to the post of bench clerk grade 1. Top. The land counsel for the petitioner, when a query is made to the land counsel for the petitioner, whether he has approached the appellate authority against the rejection of his representation, the answer was given in negative. The land counsel for the petitioner seeks permission of this court to withdraw this writ petition to approach the appellate authority in accordance with law. Accordingly, the writ petition is disposed of. What is your good name, land counsel?
Your Lordship, Akash Kumar Padjoshi.
Akash Kumar Padjoshi, land counsel, affiliate Virtual High Court, Bhawanipatna. Okay.
Your Lordship, I would like to mention one thing with the kind permission of Your Lordship.
Yes.
He is about to be retired in next 4 months, Your Lordship. That's why.
You file your you can get first file it immediately so that it can
Committee
be
will take care.
It can be taken care of by the appellate committee.
Yes, yes, Your Lordship. Much obliged, Your Lordship.
Kalahandi at Bhawanipatna. Yes.
Item 26. Supplemental list, item number 1.
May I please? Kindly see the order dated 18/1/19. 18/19 order.
Yes.
Paper book not given, madam. Paper book.
Not given ମାନେ ଆମେ କଣ କରାଯିବ ଏଇଟା ତ ସବୁ ନୋଟିସ ହଉଥିବ ନା 2018 ମସିହାର
ହେଇନଥିଲା ପେପର ବୁକ୍ ସେତେବେଳେ
appeal
18/19 ଡାଇରେକ୍ସନାଲ ପେପର ବୁକ୍ ଟା ତିଆରି ହବା ପାଇଁ
ପେପର ବୁକ୍ ତ କେବେଠୁ ହେଇଯିବଣି
ହେଇଯାଇଛି।
ହଁ ତ ଆପଣ ନେବେନି ରିସିଭ କରିବେନି ତାର ଦାୟିତ୍ୱ କାହାର? କଣ ନା
ଅନୁଗ୍ରହ ନାରାୟଣ ସାମନ୍ତରାୟ ଶତପଥୀ ହେଇଯାଇଛି।
সেটা কোন হবো?
সামন্ত রায়।
অনুগ্রহ
নারায়ণ
নারায়ণ সামন্ত রায়। তো পেপার বুক আজ দিয়ে দিয়েছেন?
না দেইনি।
দিন হ্যান্ড ওভার করবেন। মিস্টার অনুগ্রহ নারায়ণ Samant Rai, learned counsel for the petitioner, is present. He submits that he has not received copy of the paper book. A copy of the paper book is supplied to him in court. Court of this matter. Next week you get ready. This matter will commencing from 25th of November 2024, indicating the name of the learned counsel correctly as Anugraha Narayan Samant Rai in the cause list, as well as in the top of the brief for this. ये कर दिए जो पेपर रिसीव कर ले on order sheet to sign for the sign next.
Item 2.
There is a file application for bail.
The hearing distress production. Yeah.
Application for bail in respect of the lady Miller, Aisha Begum. She's in custody from 2015. No direct evidence.
No.
Circumstantial evidence is the.
This is your first application or?
First application. I am sorry at the outset that although earlier IA number 96 of 2022 is pending in respect to the parent petition for whom I am paying bail and including the other appellant Himadri Shekhar Das alias Rahim Khan. But inadvertently I have filed the present IA number 244 of 2024.
No, that was filed for
two persons, my lord.
So now you have filed another
of the same. Yes, my lord. One of those two persons, my lord.
So you are the counsel for both the appellants?
Yes, my lord.
Why don't you not press that earlier application?
Yes, my lord. My lord, say so. IA number 96 of 2022.
96 of 2022. And counsel for the appellant does not want to press this application. Accordingly, IA is disposed of or not pressed. Not press. बाकी अपन को IA number 244 of 24.
Mal.
IA का बात कर लें. So this is filed for Aisha Begum.
Mal.
So P02-120B, 392, 397. Okay. What is the prosecution case?
Prosecution case, my lord, as for the prosecution case,
four
person.
Court model number 2 of the judgment.
Mal. Listen. The case of prosecution, Krupa Sindhu Malik, the informant, lodged the affair with IIC Astaranga PS to the effect that Dinabandhu Malik, his brother, who was staying at Dinodia with his family, and he was having a grocery shop at a distance from his house on 22/9/2015 at about 7 p.m. He came to know that the shop was not open in the morning and the lights were not switched off. He came to the house of deceased and found Dinabandhu Malik, his wife and 2 daughters were murdered and there were multiple cut injury on their person. The IIC registered Astaranga PS case of such and such and took up the investigation. The IIC requisitioned the scientific team, including the dog squad. There was multiple cut injury on the dead bodies.
4 murders, yes.
2 male, the 2 parents, that means
daughters,
husband, wife, and the children, and no direct evidence. And the materials is the circumstance evidence. After about more than 1 month, some odd days, although during that particular period, other co-accused persons were arrested, the present petitioner allegedly arrested from Raipur, and they were it is alleged that one knife was seized, and it was also found that one injury is also found on the body of the.
No, what are the materials against you?
Then let me turn to page 9 of the judgment. The circumstance, my lord. May I place it, madam?
No. 9 किसी 9 it is circumstance region.
I guess circumstance region. सिर्फ पे
9 में तो लिखा है during investigation.
नहीं page 9 है क्या?
Page 9.
आगे para 8
Page
madam.
9 तो principal region.
Page 9 of the judgment para 8 madam.
Para 8 is principle.
Principle of the appreciation of circumstantial evidence.
No, madam,
what are the circumstances against you?
I am sorry then para 8 my lord. Para 8 of the page 9 of the input judgment madam.
That is what
para
is
8.
Principle.
Para 8. There was no eyewitness to the ghastly murder.
Case is based on circumstantial evidence.
नहीं
সেটা তো circumstance ওরা দিয়েছেন।
I guess circumstance ওরা যা
circumstance এর
principle ଦେଇଛନ୍ତି। এটা ନାହିଁ এটা ଇଏ ନାହିଁ circumstance ନାହିଁ।
sorry. The circumstance to elaborate କରିଛନ୍ତି।
So, Mr. Nayak, what are the materials against this lady as per the impugned judgment?
So far, this case is concerned that is allotted to the Prabhu Prasanna Behra. He's saying that he's done for difficulty. That's why I'm.
No, we just want to know that what is the.
Then, one knife has been allegedly seized, madam.
Please prove from the judgment.
Yes, madam.
Discussion, some findings.
Yes, madam. Yes.
Because it's a case of 4 murders.
This circumstance, the court has elaborated on it.
You come to page number 33, paragraph 22.
May I please?
Yes, sir.
The chain of circumstance in the present case is as follows. Both the accused Himadri Shekhar Das alias Rahim Khan and Aisha Begum were present in the incident night in the house of deceased is proved at Dinabandhu Malik declined to accompany Procedural 5 to attend the obsequious feast of late Nakula Behra.
So you are last seen in the company of the deceased.
In such a case, Procedural 1 is the person who has said that I have heard. But not
considered we are not.
Yes, madam. I'm pressing, madam. The investigation of the second, madam. The investigation of the case was taken up by the crime branch. The team of officers who are working with the DSP such and such. Procedural 13 accused Himadri Shekhar Das alias Rahim Khan and Aisha Begum after committing murder have taken away the other valuables including one Nokia 114 mobile handset. This is Dinabandhu Malik. The Inspector of Cybercrime, Procedural 15, with the help of all nodal officers of mobile service providers of Odisha, would successfully located by tracking the IMEI number of the Nokia 114 mobile phone of deceased Dinabandhu Malik and apprehended them in such and such place, Assam. Both the accused person have changed SIM card and used the same mobile handset having the IMEI number.
So this is the second
one. Third, my lord, both the accused came to the house of the deceased and gave recovery of the Kottari, MO1 and knife MO2 in presence of witnesses, and their disclosure statement was recorded. Third, the gold ornaments of the deceased Nirmala Malik, wife of deceased Dinabandhu Malik, were seized from the goldsmith in melted from one metal bangle of deceased, which was found at this soft edge. It has no value. Fourth, after committing the murder, both the accused left the house with motorcycle of deceased Dinabandhu Malik, and the motorcycle was left in a bush near such and such place, and the accused Himadri Shekhar Swai gave recovery of the same. Both the accused used weapon in committing the murder, and there were resistance and tussle. Yes, madam. Sorry, tussle in the process for which both the accused sustained injury in their hands, and both of them were examined by the doctor. PW 31. Both of them were having three scar marks of old injuries found on the right palm, and the age of injuries were within 20 days. The accused complained pain in the injuries, and it was tingling sensation. Accused Aisa Begum were found with one scar mark of old injury over the left index finger, and age of injury might be more than 20 days. The incident took place on 21/9/2015, and the injured accused were examined on 11/10/2015. Both the accused have come to Raipur
from
Raipur with newly purchased Katuri, ammo such and such, and knife such and such, and reached at the house of deceased Dinabandhu Malik at about 4 p.m. and stayed in the house, and in the night they committed murder in cold blood of all family members. The motive of preparation of commission of offences are proved from this circumstance. There is no any other conclusion that those two accused persons in conspiracy with the accused Fakir Mohon Malik committed the murder of all four deceased.
Now we come to that paragraph 24, page 36.
The motive for murder of innocent person is the night was only for money, as both the accused have taken away the mobile phone and gold ornaments. With regards to the allegation against accused Fakir Mohon Malik is concerned, he has brought accused Rahim Khan and Aisa Begum to the house of deceased and introduced accused Rahim Khan as his godson. Both the accused got access to the house of deceased, and local people have seen Fakir Mohon Malik coming to the house of deceased Dinabandhu Malik. In the incident night, both of them committed murder of Dinabandhu, his wife, and two daughters, aged about 10 and 4 years, and all the inmates were murdered brutally in the night by use of katuri and knife, which were brought from Chhattisgarh. In the meantime, accused Fakir Mohon Malik has telephoned Rahim Khan on the date of incident, that is 21/9/2015. This evidence in the present case of circumstantial evidence will go against accused Fakir Mohon Malik. The accused person have taken the plea of denial. They have not come to Odisha nor killed any of the deceased. The statement of the deceased Dinabandhu in the evening that he would not attend the obsequious feast of Nakula Behera due to presence of these accused. The accused is of these accused in Kotari, such and certain knives, and reached in the house of deceased Dinabandhu Malik at about 4 p.m. and stayed in the house, and in the night they committed murder in cold blood of all family members. Their motive of preparation and commission of offence are proved from these circumstances. There is no any other conclusion that these two accused in conspiracy with the accused Fakir Mohon Malik committed the murder of all the accused.
So, who has stated about the last scene?
Last scene?
Yes, you are. Both of you were found in the house from that. Next day, you are seen going away in the motorcycle. Then it was found that there has been robbery, and that mobile phone was recovered from your possession, and you have
PW 6, 7, and 8, they are the official witnesses. We realize that they have also procured, they have also taken from Odisha to Raipur for the purpose of arrest of the person, and it is the alleged that during interrogation, the present appellant, present petitioner, along with the other person, they brought from Raipur, they kept inside the crime branch office, and on the next day, it is alleged that while interrogation, they have disclosed. So that is 6, 7, and 8 who are the official witnesses.
No.
And so far, Pedal 1 is concerned, he is the person who is said like this, I am placing.
No, we are asking you a pertinent question, Mr. Chan. Who are the witnesses to the last scene? Because the evidence, as we saw that while jotting down the circumstances, one is that both you and that other man, they had come to the house of the deceased on the date of occurrence.
Last night.
Okay. So somebody must have stated like that they had seen you coming to the house, and again you too were seen leaving that place
in a motorcycle of the deceased.
Okay. Then third thing is that it was found that robbery has been committed. And fourth thing is that the mobile phone of the deceased was found from your possession and you have changed the SIM. So apart from that, other things are there. You gave recovery of those deadly weapons with which the murders are stated to have taken place. So many things are there. And moreover, it's a case of 4 murder.
Yes.
So why will be granted bail?
7 except detention and I am lady my lord. That's
7 years
Not-
only.
But it's a case of 4
No.
murders. It cannot be an entire family has been
Completely
See this,
washed out.
what is the age of those 2 children?
And for
10
and for
4.
robbery.
For robbery you have
Yes.
committed. Not the learned counsel for the petitioner, learned counsel for the state. It's a case where 4 murders have been committed, and though the case is based on circumstantial evidence in view of the available materials on record, we are not inclined to release the petitioner, so Lady Nataji filed IA number 1 on bail. Since paperwork has already been prepared, the matter will be added to the hearing list in the month of January 2025.
No.
Paperwork, later copy of the paperwork be handed over to Mr. Manas Chand, learned counsel for the appellants. The names of other counsel except Mr. Manas Chand and his associates shall not be reflected in the court. Yes, give the paperwork.
Okay.
Item number 3.
Here last time already called for
Custody
the report.
certificate.
Custody certificate perhaps it has come.
Already.
So ballot called for the instruction that whether during that interim period whether any adverse remark has been found or adverse report has been found against the appellant or not.
Where is the custody certificate? It was mentioned
No,
that
what?
you have to produce the custody certificate.
No, it was there, but I'm sorry that it was there. They have produced.
Mr. Mahanti.
I'm supplying. No, only first.
Yes, Mr. Tripathi. Well, you are for the informant. So anything reported adverse against this man when he was on interim bail?
No.
What is your instruction? No.
Instruction that, my lord, they have involved in 2 number of cases. Earlier,
And
my lord, they have also assaulted a person for which 70% disability.
No, this case, he was earlier granted
23
interim bail.
Two
All those
occasions.
things have been considered. What is the order dated?
Last order.
One is for 21/5/24.
My
lord, I am concerned in the criminal appeal 178 of 22 Sukadev Rao. In this case, my lord.
Wait, we are.
Lordship, I am 225 or 22 Prakash Parida, my lord.
Madam, I said 21/5/2002.
That is one order in which you are appears that you are released on interim bail
Mile.
for 2 months.
As far as time.
One case, my lord, report has come. In other cases, report has come.
Antecedent, that's not.
Total period କେତେ ହଉଛି?
8 ବର୍ଷ
8 ମାସ
3 ମାସ 21
ଆଜ୍ଞା ଆଜ୍ଞା
ଡେଟ୍ ହଉଛି 26/9
ଆଉ ମାସେ
26/9 ମାନେ ଆଉ
ମାସେ 1.5 ମାସ ମିଶିବ
8 ବର୍ଷ 6 ମାସ
ଆଜ୍ଞା
ବାକି
Sukadev, my lord,
please have your patience. There is one case apart from this case. The other case is Saranpur PS case number 136 of 2012. Right.
That report has come in respect to CRLA 231 only.
231
231 भगवान
भगवान alias
भगवान आचार्य
भगवान दळबे
हाँ
आगे
Bhagi alias Bhagirathi alias Bhagavan.
भगवान दळबे
That item on the check.
Yes.
आगे
CRLA. So 1302 is this case, the present case.
आगे
Saranpur PS case number 20.
Ida.
हाँ हाँ এটা হচ্ছে Saranpur PS case number 20. আরো একটা কেসটা হচ্ছে 2012
हाँ
341 323 so on. আচ্ছা গোটে থর আপন বেল ଦେଇଛନ୍ତି interim
before twice or thrice my lord I'm sorry that twice or thrice I'm thrice तीन थर आगे twice or thrice
সেটা যাইছিল
but it may be but it is I've been granted well ये देखो ना देखो ना
4/11/22 रे
ହଁ 4/11/22 ଆକଚୁଆଲି ନାଇଁ ଆଉ ଗୋଟେ ଅଛି 23/9/22 ରେ ଯାଇଛି
ତାପରେ
23/9/22 ରେ interim bail for 2 weeks ଯାଇଛନ୍ତି ହେଲା father expired
ଆଜ୍ଞା father death
ଇଏ ଗଲା ଗୋଟେ ତାପରେ 14/11/22 ରେ ଆପଣ ଯାଇଛନ୍ତି 6 weeks
ଆଜ୍ଞା
14/11/2022
thrice
ତାପରେ ତ ଲାଷ୍ଟ ଟାଇମ
ଆଜ୍ଞା ଆଜ୍ଞା thrice ଏଇଟା ହলো
21/2024
so my
So it
submission
is third time. What about his conduct?
did that conduct certificate is not
But he said that
that I have
nothing adverse is reported.
but the report is not come with it from the police only two report another report was confirmed whether the document file is genuine not that it is of the
Document genuine.
ସେଇଟା ତ ପୁରୁଣା that
ତିନିଟା କେସ୍ ମିଶେଇ ଦେନି
ଲାଷ୍ଟ occasion lordship ଯାଇକି ସେଇ ରିପୋର୍ଟ କିଛି ଆସିଛି
231 ଉପରେ submission କରନ୍ତୁ
231 ରେ that only whatever report comes there but
and the order last order is dated 4/11/24 you made a submission that you are to bring the custody certificate and obtain the instruction about the conduct of the petition while on interim bail. Informant counsel submit that there is nothing adverse.
the custody certificate they have got what the conduct that so far during period of interim bail I have to obtain to that.
See the instruction is in your phone.
So while it is 392 of 120.
ଆଗରୁ ଅଛି ସେମାନେ
Huh? On such and such a Madri Das alias Rohini committed robbery of jewelry, mobile phone. In course of the robbery, they have killed. Single murder? Single murder?
Piecemeal instruction from answer.
Whatever there I may be excused, whatever there I am to assist.
Order is very clear
My lord.
that you are to produce these two things.
My lord.
You are only producing.
I may allow some time that I will obtain that instruction with regards to the other appellants also. No, ସେମାନଙ୍କର କିଛି ଆସିନି
ତାଙ୍କର custody certificate
ନା ନାଇଁ nothing
ସବୁଥିରେ order ହେଇଥିଲା
ଆଜ୍ଞା ଆଜ୍ଞା
ଦେଖନ୍ତୁ the Learned Counsel for the state ଏଇଥିରେ ଲେଖିଦେବେ order 231 of 2020 Learned Counsel for the state has produced the custody certificate of the appellant to also instruction written instruction regarding the criminal antecedent. However, he submits that he is yet to receive the instruction regarding the conduct of the petitioner while on interim bail. And some more time may be granted. So also he will produce the custody certificates of the appellants in the connected criminal appeals. ସେମାନେ କଣ interim bail ଯାଇଥିଲେ
ଆଜ୍ଞା ଆଜ୍ଞା
and also their conduct while on interim bail. So this matter is to be listed along with for the procedure number 177 so and so. This is taken on record.
Malad in one.
ସବୁ ଗୁଡାକ ଆସିବ ଏକାଠି
Like 177, he has not been granted interim bail.
ଆଚ୍ଛା
No, Malad. Sudhanshu Raut.
170 ଆଚ୍ଛା ତାହେଲେ କୋଉଥିରେ interim bail ଯାଇଛନ୍ତି କୁହନ୍ତୁ
170. 178.
170 ରେ interim bail ଯାଇଛି
178 ରେ ଯାଇଛି ସୁଖଦେବ ରାଉତ।
ହଁ ଠିକ ଅଛି ଆଉ କିଏ ଯାଇଛି
Lordship 225 ରେ ପ୍ରକାଶ ପରିଡ଼ା interim bail ଯାଇ ନାହାନ୍ତି।
ଯାଇ ନାହାନ୍ତି
ନା no minor।
ମୁଁ
ଯାଇଛନ୍ତି କିଏ ଅଛ
ଯାଇଛନ୍ତି only 178।
231 ରେ ଯାଇଛି
Yes, madam.
215 କଥା କହିଲେ ଆଚ୍ଛା 225 ପ୍ରକାଶ ପରିଡ଼ା
ଯାଇ ନାହାନ୍ତି।
231
ଅର୍ଡର ରଖାଗଲା ଆଉ 177 ଯାଇନାହାନ୍ତି
177 ଯାଇନାହାନ୍ତି।
ତାହେଲେ custody certificate of the appellant in Sukadev Raut alias କଣ Hina in CRN number 178 of 2020
Yes, madam.
ହେଲା along with their criminal activity ହେଲା yes next ଗୋଟେ ପରେ ଆସିବ
Item 4.
My lord, in this case, my lord, 3 appellant are convicted in this case, my lord. 2 appellant are released on bail before the honorable court. My lord, in appellant are custody more than my lord 9 years above my lord. He is in custody 8/3/2015, my lord.
No, we have granted bail to one Rajani Parida.
Ramachandra Parida, Rajani Parida.
ଦି ଜଣ ଯାଇଛନ୍ତି ରଜନୀ ପରିଡାର ଗଲା ରଜନୀ ଗଲା 1/10/2024 ରେ ଆଉ ଗୋଟେ କିଏ
ରାମଚନ୍ଦ୍ର ପରିଡା
ସିଏ କେବେ ଗଲା
ସେ ତାଙ୍କ ଆଗରୁ
ଡେଟଟା
ଆଗେ
ହଁ ସିଏ ଯାଇଛି 15/7/2024 ରେ so you are the only person left out
yes ma'am
ତିନିଟା ଲୋକ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ
ଆଜ୍ଞା
okay so you are Ranjan Parida
he is the main culprit
so are you the main culprit or what
no ma'am
498/304B 302
husband to
husband ବୋଧେ ଆପଣ
I am husband ma'am
ତ କଣ ରୋଲ କଣ attributed
set at ablaze by powering kerosene
କିଏ dying declaration
dying declaration
କଣ କହୁଛି
ଯେ ମତେ ସ୍ୱାମୀ ଶ୍ୱଶୁର ଶାଶୁ କିରୋସିନ ଢାଳି ମାରିଥିଲେ
ସେମାନଙ୍କୁ ବି ନାଁ ଅଛି
ହଁ
ଏଭିଡେନ୍ସ କେତେ
ଡକ୍ଟର
ଏଭିଡେନ୍ସ
exhibit 7 my lord exhibit 7 my lord dying declaration
no recorded by the doctor or
SCP my lord
SCP ରେ
executive magistrate
exhibit 7 କଣ କହୁଛନ୍ତି ବାଛୁ ହଁ ବାସ୍ ସେଗୁଡାରୁ
PW
ତୁମର ନାମ କଣ ଗଲା କହିଲା ଘଟଣା କିପରି ହେଲା ମୋର ସ୍ୱାମୀ କିଛି କାମ କରନ୍ତି ନାହିଁ ସ୍ୱାମୀ ମାନେ ୟୁ
yes my lord
ମତେ ସବୁବେଳେ ବାପ ଘରୁ ଟଙ୍କା ଆଣିବାକୁ କହେ ମାଡ଼ ପିଟା କରେ ଗତ ସୋମବାର ଦିନ ପଇସା ଆଣିବାକୁ କହିବାରୁ ମୁଁ ମନା କଲି ସେ ରାଗି ଯାଇ ମତେ ଘରୁ ବାହାର କରିଦେଇ କବାଟ ବନ୍ଦ କରିଦେଲା ଲୋକମାନେ ପାଟିତୁଣ୍ଡ କରିବାରୁ ଦିଅର ଘର ଭିତରକୁ ଟାଣିନେଲା ଘର ଭିତରେ ସ୍ୱାମୀ ଦିଅର ଶାଶୁ ଶ୍ୱଶୁର ମିଶି କିରୋସିନ ଢାଳି ନିଆଁ ଲଗାଇଦେଲେ ମୁଁ ବାହାରକୁ ଚାଲି ଆସିଲି ଲୋକମାନେ ନିଆଁ ଲିଭାଇ ସେତେବେଳକୁ ସଫଳ ସ୍ୱାମୀ ଆଉ ସେ ଯୋଉ ବାକି ଏମାନେ କୁଆଡେ ଗଲେ ଯୋଉ ଦିଅର କୁଆଡେ ଗଲା
ସେ ରେଷ୍ଟ
କେବଳ ବାପା ମା
ହଜବେଣ୍ଡ
ପୁଅ
ଚାର୍ଜସିଟ୍ ହିଁ ନେଇଥାନ୍ତା
ନା ତାହେଲେ ଚାର୍ଜସିଟ୍ ନାହିଁ।
Final formula Ranjan means you.
Yes, ma'am.
Ramchandra Parda released on bail. Ranjani Parda released on bail. Absconder ବୋଲି ମନୁ ଆଲିଆ ଷ୍ଟିଫନ୍ ପରିଡ଼ା ଛାଡିଦବ କିନ୍ତୁ ଡାଇଂ ଡିକ୍ଲାରେସନ ନା ଅଛି କୋଉ ଦିନ ଛାଡି ଦିଅନ୍ତି
4 ମନୁର 4
ହଁ
absconder charge
absconder charge as there is prima facie evidence under so and so and monu alia Stephen Panda charge sheet ହେଇଛି 498 302 304 by 34 4 DP Act.
So Ramchandra, Rajani and Manu are absconder ଥିଲେ କେବଳ ଇଏ ଥିଲେ।
ଏଟା ଆପଣଙ୍କର ପିରିୟଡ କେତେ ହେଲାଣି?
ହେଲା 9 ବର୍ଷ 7 ମାସ 13 ଦିନ ହେଲା।
ମ୍ୟାରେଜ ର କେତେ ଦିନ ପରେ?
2 month ହେଲା।
କେତେ ଦିନ ଭିତରେ ହେଇଥିଲା ମର୍ଡର?
ମ୍ୟାରେଜ ର 2 month ହେଲା।
Within 2 months of the marriage?
ଆଉ ଇଏ ବେଲ ଆଗରୁ ଯାଇନାହାନ୍ତି?
ନା ଆଜ୍ଞା।
9 years କେତେ?
9 ବର୍ଷ 7 ମାସ 13 ଦିନ।
The learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody on 6/3/2015 and he was neither released on bail during the trial nor before this nor by this court during the pendency of the appeal. He further submits that the co-accused persons who are the parents-in-law of the deceased Nagana?
Ramachandra Parida,
Ruby Parida have already been directed to be released on bail. Ramchandra hochi 15/7/2024 ଆଉ ସେ ଯୋଉ mother in law ହେଲା 1/10/2024. The land council further submits that the case is based on mainly on the dying declaration of the deceased before Dr. K.
Dr. Peterson 19
and Dr. is na executive magistrate.
No, executive magistrate.
Executive magistrate.
PW 18. PW 18.
Which was recorded by doctor record kala na is executive magistrate record kala?
Executive magistrate.
Executive magistrate record kala. Doctor present recorded by the executive magistrate bracket record then to PW 18.
PW 18 तो PW 18 is SI of police. I was working as SP Zone 2. Or with the executive magistrate power only kouchan. SCP Zone 2 only. Same time.
As per Urban Police Act,
Section 56. Correct. In my presence, as well as in the presence of sponsor, I recorded this statement. So this PW 18 has recorded this.
Yes.
ACP through exercise of power the Urban Police Act.
Recorded the dying declaration also. The land council further submit that the petitioner had good chances of success in the case and balance and convenience is in his favor and therefore the bail application may be favorably considered. Land council for the state submits that the petitioner is the husband of the deceased and the occurrence took place within 2 months of marriage and it's a case of burn injuries and the deceased has stated in the dying declaration how she sustained the burn injury in which the name of the petitioner and other in-laws find place. Therefore, should not be released on bail. We place the evidence of PW 18 and PW 19 of stated above the recording of bank declaration of the deceased. Doctor K.
PW 19, my lord.
Doctor Kirna, the
Dr. Santosh
Doctor
Kumar
ने postmortem
Dr. Santosh Kumar Behera, sir, Doctor. PW 19, my lord.
PM doctor is not
PM doctor no.
Dr. 19 ଯାହା ପ୍ରେଜେନ୍ସ ରେ
bank declaration
ରେକର୍ଡ
recording.
19.
So that is 19. What about the doctor who conducted PM examination? Or that is PW 14.
14.
And also the evidence of PW 14 was stated that the deceased has sustained 50% of burn injuries. And the cause of death has been opined due to burn injury and its complications. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced during trial, particularly the evidence relating to the dying declaration, even though the co-accused persons who are the parents-in-law of the deceased have been directed to be released on bail, we are not inclined to release the petitioner on bail on merit. However, taking into account his period of detention for more than 9 years and 7 months, we are inclined to release him on interim bail for a period of 3 months. Disposed of. And then you fix a date so that you file the surrender certificate. Yes.
Item 5.
petition has been received at flag C, on the basis of prisoner petition we are appearing. And
Have you filed your VNAMA?
Yes, my lord. On 27
single appellant.
single appellant, my lord.
Judgment का देखेंगे.
IA has not been served. IA copy has not been served.
Like to pay you the prisoner's petition at flag C, in which prayer has been made for engagement of Mr. Biswajit Naik as his counsel in place of Mr. J. Kamila. Stop. Mr. Naik has already filed his Bhinama. The Bhinama is accepted. The name of Mr. J. Kamila shall not be reflected in the cause list henceforth. Is what you want further?
My lord, the deposition copies are not available. I may be permitted to take the deposition.
The learned counsel for the appellant submits that the deposition copies are not available with him, and he may be permitted to take the deposition copies in his pen drive. Let the registry supply deposition copies of the witnesses to the learned counsel for the appellant in his pen drive. Yes, next, put up this matter with a date.
My lord, maybe in the week commencing 2nd December.
Okay, 2nd December. 2nd December.
Grateful.
IA copy may be served.
पड़ेगा यदि matter पुनी देई हवन. Yes, next.
IA copy may be served.
Select a copy of the interim application. Interim application. Dinta को दरकार किसी नहीं.
किसी नहीं.
अब अच्छा, interim applications be served on the learned council for the state. Yes.
Item 8.
Item 8, my lord.
State to obtain custody certificate.
Yes. They are sending the letter, but they are not received the custody certificate.
Who jealous?
Kujang.
केबे ऑर्डर ହେଇଥିଲା କି 7/11 ହେଇଥିଲା. अच्छा और नेक्स्ट वीक रे रखु नहीं आसुन पठेजन तो
Custody certificate.
अपन बारे
No, you
No, no, they will
directed
bring.
my learned friend to obtain whether he has been released during that COVID period.
That is everything will be there. Everything
टोटल आसी जीवो केबे रहिचंदी इंटरिम रे केबे जाइचंदी सब डिटेल उडा आजिवो टोटल मध्ये देई देइथिबे A plus B plus C करी एतिकी डेज विल दियंती समान. That can also be prisoner चाहिले मध्ये समान देई दोछंदी. Why are you
My instruction that he was not released during that COVID.
हमें कहया
No, custody certificate
custody certificate आपण चाहिले and that was the division bench order of this court that custody certificate ता furnish करिवे पार्टी मध्ये चाहिले तो
I will also try my best.
all right, learned counsel for the state submits that he is yet to receive the custody certificate and the matter will be taken up a week after this matter on 2nd December as you. Yes, sir. Mr. Nayak, ये ready है चल के.
madam.
Item 46. Hearing with
46 से काली युक्ता कहउतले इंटरिम एप्लीकेशन.
एप्लीकेशन आए भी अच्छी से थरे एटा हियरिंग रे आछि. जो जुवेनाइल अछि जो भितरे.
हां फाइल को ले आई दैट आई
एटा अच्छी थरे अच्छी. माइलडा
गोटे आई तो अच्छी इट इज ओनली फॉर बेल.
हां आई.
Oh, but that has come in the hearing list. Are you ready for hearing or what?
Sir, collected some judgment, so yes, my lord, I am ready.
My
My lord, I am ready. I am ready for hearing. Hearing the matter, my lord.
Mr. Counsel, you made a submission yesterday that you intend to file an interim application for consideration of his juvenile. ତେଣୁ ଆମେ ଆପଣଙ୍କୁ କହିଥିଲୁ କାଲି ଯେ ଆପଣ ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ରେ ଯଦି ଚାହୁଁଛନ୍ତି ଦିଅନ୍ତୁ. ଆପଣ ନ ଯାଇକି ଆଜି କଣ ପୁଣି ବେଲ୍ ମୁଭ୍ କରିବାକୁ କଣ ବସିଲେ? प्रत्येक दिन आपनकर स्टैंड चेंज होची ना को
छिते आयटा अछि नै पचरथिला आयटा अछि स्त्री
काई आयटा अछि कनै त
आपण गोटे
क्लेमिंग जुवेनिलिटी ताऊ पताले सर बेल पे
एटा अछि तापर गोटे विड्रॉल मेमो फाइल कर जे आईए पई
ୱିଥଡ୍ରଲ୍ ଟା ଫାଇଲ କରିଛି ସେଟା ବେଲଟା ଯଦି ଆସିବ ତାହେଲେ ଅନରେବଲ ଚିଫ କୋର୍ଟ ଆଣ୍ଡ ବିପି ର ଅନରେବଲ
ଆମେ ଏତେ କଥା ଜାଣୁ we are disposing of that BL application. देखो IN number 2335 of 25 is an application for bail, है ना? Learned counsel for the petitioner has filed a withdrawal memo of that interim application. Accordingly, IA is disposed of as withdrawn. Yes. कौन-सा फाइल करिए?
Bail application.
You can file.
Liberty release of the juvenile.
You file की मना कुछ या फाइल ना को. Yes, next.
मैडम मनीमा आपने रेडी तले कोटा उठे
29 29
20
एक्सेल मारी ये अपन रेडी अछन तो
29
14 टा रेडी अछन दियो 14 नंबर
एपटे किए छन
अपन क्वाइट ला अपन डिस्ट्रीब्यूट कर देबे है ना You are ready? Alright, Jens, file. এটা ଆପଣଙ୍କୁ engagement letter issue ହେଇଛି High Court legal letters अच्छा विकास चंद्र परिजन लिखि दियौ the ମାନେ ଆଗରୁ ଇଏ କରିଦିଅ ବୋଧେ अच्छा नाली वो तो से हरे कुछ तो मान लीजिए था आइटम नंबर 14
मैल
आइटम नाली वो तो जो
से तांका पावर भी थिला से कहउतले
हां
I have offered him if you are interested then what's denied
সেটা আউট কেস
সেটা out
সেটা আউট কেস
এটা আউট ম্যাটার
এটা আউট যে जोटा कि हरिकृष्ण मल्लिक अछंती वर्तमान
अच्छा वर्तमान तो ये आर्गुमेंट दियो पेपर बुक (302, 364 and 201).
Man.
Sole appellant, no?
Sole appellant, man. The entire case is based
Okay,
on
you just come to the FIR
man.
at page 19, and that is lost by one Sabitri Mahapu. His PW.
PW one my lord, the mother of the deceased. My lord. मोर नाम सावित्री महाकुर मु आज ता 14/2/2007 बुधवार
5 ना 7 7
मान
अच्छा 7
2007
बुधवार रात 8 घंटा समय मोर सान भाई इंद्रमणि महाकुर सह सुआकाटी फांडी हाजिर होई
इंद्रमणि महाकुर कितना नंबर साकी हे नांदी
ता भाई मालट होई
साकी नांदो ନାଇଁ PW लिस्ट अछि 15 पेज रे ना दिता हां
हाजिर होई एई रिपोर्ट देउछि कि मु मोर स्वामी सासू ससुर दियर समार महाकुड़ू नणंद आमुली ओ मोर दुईटी छुआ सह खदुरी मुंडी रे रुहे मोर स्वामी एबे किछि दिन हबो कुसुम प्लांट रे काम करी जाइछन्ती मोर दियर समार कसड़ा गाँर परिडा साहिर गोरु चरांती तांकर स्त्री ओ पिलापिली तांको ससुर घरे तेलकोई गोलाबंधरे रुहंती ओ मझिरे मझिरे आम गाँ को आसंती मोर स्वामी एबे किछि दिन हबो कुसुम प्लांट रे काम करी जाइछन्ती मोर दियर समार कसड़ा गाँर
तमर मींस appellant
appellant man
କସଡା ଗାଁର ପରିଡା ସାହିର ଗୋରୁ ଚରାନ୍ତି। ତାଙ୍କର ସ୍ତ୍ରୀ ଓ ପିଲାପିଲି ତାଙ୍କ ଶ୍ୱଶୁର ଘରେ ତେଲକୋଇ ଗୋଲା ବନ୍ଧରେ ରୁହନ୍ତି ଓ ମଝିରେ ମଝିରେ ଆମ ଗାଁକୁ ଆସନ୍ତି। ଗତକାଲି ଉପରବେଳା ଘରେ ମୁଁ ମୋର ନଣନ୍ଦ ବଡ ପୁଅ ଗୁରୁ ମାନେ ଡିସିଜ୍ଡ
7 ବର୍ଷ।
7 ବର୍ଷ
ମାନେ ଓ ସାନ ପୁଅ ସୁରୁ ଓ ଦିଅର ସମାର ଥିଲୁ। ପ୍ରାୟ 4ଟା ବେଳେ ମୋ ବଡ ପୁଅ ଗୁରୁ କହିଲା କାକା କହିଛି ସେ କାକା ସହ ବେଳୁ ଖାଇଯିବ କିନ୍ତୁ
କାକା ମାନେ ହଉଛି ସମର
କାକା ହଉଛି ଆପିଲାଣ୍ଡ।
କାକା ସହ
କାକା
ବେଳୁ ଖାଇଯିବ।
କାକା ସହ ବେଳୁ ଖାଇଯିବ। ବେଳୁ ମାନେ କେନ୍ଦୁ ସେଟା ଗୋଟେ ଫଳ ଖାଇବା ପାଇଁ।
କେନ୍ଦୁ ତ ଲେଖା ହେଇଛି ଆଉ କଣ?
ଆଜ୍ଞା
କେନ୍ଦୁ ଖାଇଯିବ। ବେଳୁ କୁଠୁ ଲେଖା ହେଇଛି ସେଟା କେନ୍ଦୁ।
ଆଜ୍ଞା
କେନ୍ଦୁ ଖାଇଯିବ।
ମୁଁ ତାକୁ କହିଲି ଏବେ ତ କେନ୍ଦୁ ହେଇନି ଯା ନା, କିନ୍ତୁ ସେ ମୋ କଥା ଶୁଣିଲାନି। ତାର କାକା ସମାର ସାଇକେଲ ଧରି ବାହାରିବାରେ ଓ ଡାକିବାରେ
ତା ସହ ଗଲା।
ସେ ମଧ୍ୟ ତା ସହ ଗଲା। ସଞ୍ଜ ବେଳକୁ ମୋର ଦିଅର ସମାର ସାଇକେଲ ଧରି ଏକୁଟିଆ ଘରକୁ ଫେରିଲେ ଓ ମୋର ପୁଅ ଗୁରୁ ନଥିଲା। ମୋର ଦିଅରକୁ ପଚାରିବାରେ ସେ କହିଲେ ମୋର ପୁଅ ତାଙ୍କ ସହ ଯାଇନି। ଯେତେ ପଚାରିଲେ ମଧ୍ୟ ସେ ମାନିଲେନି। ମୁଁ ଗାଁ ଭିତରକୁ ଯାଇ ମୋର ଛୁଆକୁ ବହୁତ ଖୋଜାଖୋଜି କଲି, କିନ୍ତୁ ତାକୁ ନ ପାଇ ଗାଁ ଲୋକଙ୍କୁ କହିଲି ଓ ପୁରୁଣା ମେମ୍ବରକୁ ଜଣାଇଲି। ଆଜି ସକାଳେ ଆମ ଗାଁର କିଛି ଲୋକ ମୋର ପୁଅକୁ ଖୋଜାଖୋଜି କରି ଗଲେ। ଦିନ ପ୍ରାୟ 11ଟାରେ ମତେ ଖବର ଦେଲେ କି ମୋର ପୁଅ ଗୁରୁ ମର୍ଡର ହୋଇ ଆମ ଗାଁର 2 କିଲୋମିଟର ଦୂର ସିଆନାଳ ଜଙ୍ଗଲରେ ପଡିଛି ଏବଂ ତାର ବେକ କଟା ହୋଇଛି। ଏ ଘଟଣା ଶୁଣି ମୁଁ ମୋର ସାନ ଭାଇ ଇନ୍ଦ୍ରମଣି ମହାକୁଳକୁ ଖବର ଦେଲି। ସେ ଆମ ଘରେ ଆଜି ଉପରବେଳା ପ୍ରାୟ 5ଟାରେ ପହଞ୍ଚିଲା। ତାକୁ ସବୁ କଥା କହିଲି ଓ ମୋର ସ୍ୱାମୀକୁ ଖବର ଦେଲି। ମୋର ସ୍ୱାମୀକୁ ଅପେକ୍ଷା କରି ଡେରି ହେବାରୁ ମୋର ଭାଇ ଇନ୍ଦ୍ରମଣି ମହାକୁଡ ସହ ଶୁଆକାଟି ଫାଣ୍ଡିକୁ ଆସିଲି। ମୋର ପୁଅ ଗୁରୁ ମହାକୁଡକୁ ଗତକାଲି ତା 13/2/2007 ତାରିଖ ଉପରବେଳା 4ଟାରେ କେନ୍ଦୁ ଖୁଆଇ ନେବ କହି ଭୁଲାଇ ମୋର ଦିଅର ସମାର ମହାକୁଡ ତାକୁ ସିଆନାଳ ଜଙ୍ଗଲକୁ ନେଇ କୌଣସି ଧାରୁଆ ଅସ୍ତ୍ରରେ ବେକ କାଟି ମାରିଦେଇ ପକାଇଲେ। ଆଜି ସକାଳୁ ଫେରାର ହୋଇଯାଇଛି। ଏଥିରେ କୌଣସି ସନ୍ଦେହ ନାହିଁ, ତେଣୁ ଏହାର ଉପଯୁକ୍ତ ବିଚାର ହଉ।
Okay, so is a case based on circumstantial evidence. So what are the circumstances?
Circumstantial manner lasting theory.
Is it discussed anywhere in the interim judgment? ତାକୁ jotted down କରିଛନ୍ତି ଏଇ ଗୁଡାକ ହଉଛି circumstance ବୋଲି ନା ନାଇଁ ସେମିତି କିଛି କରିନାହାନ୍ତି?
Page 8 ମାନେ
internal page 8 ନା running
internal page 5?
Internal page 5. ମାନେ ଏଇଟା ହଉଛି ପ୍ରିନ୍ସିପଲ ଯେ ଏଇଆ ଅଛି।
it is lasting theory
leading to discovery.
It is page 9. Internal page तारा judgment 6. 6, 7. 6, 7 PW 1 set था किंतु discussion is later. Discussion is later.
अच्छा କହିଦେଲେ ଗୋଟେ ହେଲା last scene ତାପରେ
leading to discovery.
Just a minute. Leading to discovery
and confession.
Extrajudicial confession.
Yes.
ना से जो
before the police.
Before the 27 ना जो 27 है से तो leading to discovery है। Last scene evidence की पूछेंगे।
Last scene PW1 mother of the district.
Only.
नहीं 3 PW3 the
एक के 3 याव किए।
Okay ना।
अच्छा leading to discovery of what?
Acts.
मतलब की पूछे?
The 4 and 2
PW
and 4. 2 and 4.
PW2 and PW4.
मतलब
and of course the IO. IO कितने नंबर से की?
IO मतलब PW8 मतलब
PW7.
PW7 is the IO.
PW7.
So last scene is there, leading to discovery is there.
Bloodstain wearing apple.
How bloodstain ଅଛି କौन?
She reported
Bloodstain, my lord.
all these documents so that the half pant of the accused
But the
is
axe,
written.
there is no blood on the axe.
No. See, କୋଉଥିରେ କଣ ବା bloodstain ଆପଣଙ୍କର wearing
Human blood.
apparels ରୁ
ଅଛି wearing apparels blood
T-shirt of
ଅଛି.
the deceased half
wearing
contained human
अच्छा,
blood.
wearing apparels
Bloodstain.
bloodstain अच्छा एतिकी. Okay. The cause of death as per the doctor's evidence?
Doctor's evidence hemorrhage due to injury to carotid vessels.
No, कौन sarcoiting weapon रे?
Man.
Man.
Chalk na कौन?
It is observed by the doctor that the injury is sustained.
Who is the doctor?
PW5.
Page 40.
Let us come to that evidence first.
Page 40.
Inside don't पड़ा? On right.
और नाई पूछूंगी.
Inside don't.
Schedule 5, page 40.
Inside wound, right
जोड़े
side.
Inside wound.
Left side neck.
Yes.
Below
Below the middle of the body of the.
So all these injuries are antemortem and can be caused by sarcoiting weapon.
It is possible by that
found that larynx was cut, thyroid cartilage transversely, trachea was intact, external and internal jugular veins, common so on so were cut
and
lacerated, esophagus was cut, injuries, death of the deceased due to hemorrhage due to the injury to the carotid vessels. So ବେକ କଟା ହେଇଛି ତା ଯୋଉ ଇଏ ହେଇଛି ଆଉ କଣ homicidal death ବୋଲି କହୁଛନ୍ତି ହେଲା. So that is the injury cause. Now you come to the evidence of that last scene. PW1. ଆପଣଙ୍କର plea total denial ନା ମାନିଛନ୍ତି ଛୁଆଙ୍କୁ ନେଇକି ଯାଇଥିଲେ?
No, denial.
That age of that କେତେ ହେଲା ତାର?
7.
Age of the deceased 7 years.
7.
Come to PW1.
Madam.
She is the mother.
It is mother, madam.
And informant.
I am the informant. Deceased Guru Mahakudu was my son. Accused Samara Mahakudu is my husband's younger brother. Occurrence took place 8 to 9 months ago. Accused was staying separately from his wife and children. Myself and my family were staying with my father-in-law. Accused was also staying with us. My husband was working at a Jhumpura. Accused was quarreling with myself, my son, my husband, and my father-in-law. On the occurrence day, around 3 p.m., I was in my house. Accused took deceased from my home in a bicycle on the plea of taking Kendu. Accused returned alone around 5 p.m. the same evening. I asked accused where was my son. Accused said that he might be playing somewhere. The same night, I searched for my son, but in vain. By the next morning, accused fled away somewhere. In the morning, we found dead body of the deceased in the jungle near Sianala, which was a Nala. There were cut injuries on his face and both side neck. I went with my brother to police station and lodged a FIR. The FIR was written as per my instruction and I put my LTA. I have not seen the occurrence. Accused was living from his childhood at Gholabandha near Telkoi, and he also married there. During the period of occurrence, he had come to our house as a guest for 1 year. For 1 year, he stayed with his parents in our house, and he was earning by tending cattle of our Sahi people. In our house, accused stayed separately, and myself, my family members stayed separately, and my father-in-law, mother-in-law stayed separately. The accused was at times taking food with us, and at times taking food with his parents. We have no landed property. My parents-in-law were earning tending cattle, and we were sharing their income. The income of accused and my parents-in-law was less, and it was insufficient for even 6 months. The accused had no dispute with myself, my husband, and my son, but he was having dispute with his parents. Myself and my husband's sister, Amala, PW3, only were present in the house when accused took my son. No outsider was present near our house at that time, except myself and Amla. None had seen the accused taking my son in his bicycle. It is not a fact that the accused had
The Amla?
Amla PW3 Myler, the sister of the
Bhoni. PW1 ର ଭଉଣୀ
this appellant ର ଭଉଣୀ.
appellant.
PW3 Myler accused is my brother. Deceased Guru was my elder brother's son. Nearing a year ago, accused killed Guru. In the afternoon, accused and Guru took rice, and around evening, accused called Guru and took him away in a bicycle on the plea of taking Kendu. Accused had a tangia with him. At night, accused returned alone and Guru was not with him. I asked him about Guru. He said that Guru had not gone with him. We searched for Guru, but in vain. At night, accused fled away somewhere. The next day, the dead body of Guru was found in the jungle and his neck had been cut. The accused had no relationship with the family members, including me, but he had good relationship with Guru. Daily, accused serves himself the food, but on that day, Guru served him the food. My co-villagers were not present when accused to Guru. I cannot say where accused to Guru. In the afternoon, voting was going on for panchayat election in the school outside the village. My villagers were in that school for such election. Guru also had gone to that school. The accused fled at dawn. On the next day of the occurrence, police had not come to our village in village. In the night of the occurrence, police came to the jungle. I did not go with the police. My co-villagers went with police. Police saw the dead body in that night. On Thursday, police arrested the accused. When the accused came to the village, our villagers detained him.
ये जो line का पहिला, ये जो in the afternoon, voting was going on
at the school
for panchayat election in the school outside the village. My
Village.
villagers were in that school
for
such elections.
Guru
Guru had also gone to that school. That means Guru ଯାଇଥିଲା ସେଠିକି
to school mela. To school mela.
ଇଏ କେତେବେଳେ ନେଲା?
ଇଏ ନେଲା କେତେବେଳେ?
ଇଏ as per the evidence of the PW1 my lord, say afternoon 5 around 3 p.m.
3 p.m. ସେ ନିଜେ ଫେରିଲା 5ଟା ବେଳେ.
5ଟା ବେଳେ.
She statement the accused said from the beginning, paragraph 4 last line, that Guru had not gone with him.
From the beginning, he has stated that Guru had not gone.
Same statement, of course, he has also given that PW1 bodhe share hoichi.
On being questioned, he said that Guru had not gone with me.
Whatever the line there?
My lord.
On mic.
I asked accused where was my son. Accused said that he might be playing somewhere. That is the 3 number Saki the code देखिला.
3 number Saki. This
is my brother.
Man.
This is Guru is my elder brother's son. During a year, accused killed Guru. In the afternoon, they took rice, and around evening, accused called Guru and took him A bicycle on the plea of taking self-defense. Accused had a tangia with him. At night, Swan slept alone. Guru was not with him. I asked Guru, he said that he had passed from it. ଆପଣଙ୍କର ଇଏଟା ହଉଛି ମିଛ
ମାଇଲ
ବାହାରେ କାମ କରି ସେମାନେ ହିଂସାରେ ମୋ ନାଁରେ ମିଛ କେସ୍ କରିଛନ୍ତି। ଆଚ୍ଛା, ତ ଏଇ ଦିଟା ଗଲେ ଲାଷ୍ଟ ସିନ୍ ର ଦୁଇ ନମ୍ବର ସାକ୍ଷୀ କଣ?
ମାଇଲ ସେଟା leading to discovery procedure of tangi
ଟାଙ୍ଗିଆ
ମାଇଲ he stated
Confess
that
to police.
while the appellant was in custody, seizure was made in the police station. Man, he was in the police station
too,
but seizure was made was in his house. In his cross examination, he has stated that. My lord, I am placing this.
Just a minute. ଏ PW2 ର ହଉଛି leading to discovery ହେଲା ହେଲା କଣ ମିଳିଲାଠୁ ଆକ୍ସଟା paragraph number 3 ଆସନ୍ ଟାଙ୍ଗିଆ thereafter read ପଢନ୍ତୁ।
Thereafter, accused led me and the police to his house and produced that tangia, and police seized it under a seizure list, which is exhibit 3. Exhibit 3 one is my signature. Police seized the bloodstained earth under exhibit 4, and exhibit 4 was signature matter cross examination.
So the discovery is contemporaneous to the statement recorded.
ଟାଙ୍ଗିଆରେ ବ୍ଲଡ୍ ଆସିଲା?
No, my lord, in the there is no blood in the tangia. My lord, he stated in para 5, my lord.
Just a minute, tangia no blood.
Para 5, I have not seen the murder. I cannot say who murdered the deceased. On the date of occurrence, election was going on, and we were busy in that election. Accused belonged to a different side, and I belong to a different side. I saw the dead body at 7 to 8 a.m. Mangu Pradhan, Harihar Pradhan, and 7 to 8 others were with me when I saw the dead body. The body was found in a jungle area where bicycle cannot reach. Gagan Mahanti informed police by phone around 7 to 8 p.m. that accused was available in village. The same night, police in that jungle wrote the papers. The same night, police took the accused to PS and kept him there. Next day, police came to our village. Police took us to the dead body and brought bloodstained earth and the dead body. The seizure list as to bloodstained earth was written at that village. Police brought out a tangia from the house of PW1. In the house of PW1, the seizure list of tangia was written. Thereafter, police returned to police station. Except the seizure list of bloodstained earth and tangia, police wrote nothing else. At the time of these seizures, accused was at police station. Police had not read over and explained the seizure list to me. Being told by police, I signed those. Accused had good relationship with his parents, brother's wife, and the deceased.
So, Mr. Naik, ଯଦି ମୁଁ chief examination ରେ କହୁଛି leading to discovery କଲା ଟାଙ୍ଗିଆ ଆଉ cross examination ରେ ଅଲଗା କଥା ଆସିଲା police brought out the tangia from the house of PW1.
ସେ ଗୋଟେ ଘରେ ରହୁଥିଲେ ନା PW1 and
accused was not there along with
accused
police.
was not there.
accused
ସେତେବେଳେ କହୁଛି ସେଟା ହଉଛି ମୁଁ
ଥାନାରେ ଥିଲା।
ଯେତେବେଳେ ଥାନାରେ ଥିଲା ତାର 2-3 ଲାଇନ ତଳକୁ ପଳେଇ ଆସନ୍ତୁ। Thereafter police returned to the police station. ତାପରେ ଦେଖନ୍ତୁ at the time of seizure accused was in the police station. So how it would be 27?
And police has brought out the tangia.
Police ନିଜେ ନେଇକିନା ଆସିଲା ତାପରେ so this is the evidence of PW2 27 evidence of ଆଉ ସାକ୍ଷୀ ମାନେ କଣ କହିଛନ୍ତି 4 ନମ୍ବର କଣ
4 number say
Dead body
leading to discover
search করছি।
Huh?
He has found the dead body.
Police came to
I know the
spot, seized
accused.
bloodstain.
9 months ago, accused took Guru to the jungle and killed him there.
Oh, your dead body
Being told by the family member of the Guru, we searched for him and found his dead body is Nala, Sai Nala, jungle. Guru neck had been cut. Police came spot and seized the bloodstained earth. Under executive such and such is my signature. Accused escaped after the occurrence. When he came again to village, police arrest him. He confessed before the police that he killed Guru by Tangia. Police recorded his disclosure statement under Exhibit 2 and Exhibit 2 is my signature. Accused said police that he had concealed the Tangia in his house and that he would produce it. Then before police, he produced the Tangia in his house and police seized it under Exhibit 3 and Exhibit 3 is my signature. Police seized a bicycle which was in the house of the accused and prepared a seizure list which is Exhibit 5 and 5.1 is my signature.
cross-examination
prosecution 4 say deny kar
I had not seen accused taking Guru to jungle and killed him. Around 8 to 9 p.m. we knew it. Then we searched for a Guru in that night, but it in vain. In that night, police did not come. Next morning around 8 a.m. and 9 a.m., Guru's dead body was found. Guru's neck was cut at the right side. After Guru's dead body was found, a Faraj lodge. Many persons was Guru dead body, but I cannot name them. At night around 8 p.m. to 9 p.m., police came and I went with police to spot Guru's dead body was brought to the village. At the time of accused was not present in the house. Accused come to village 3 days after the occurrence. Before arrival of police, none had asked accused anything. Police arrested the accused, sent to him PS and interrogated him at PS. I had not gone to the police station. I cannot say what police wrote in the paper. I had not entered into the house of the accused when he brought out the Tangia and therefore I cannot say in which place in his house the Tangia are available in house in village in
all houses
in village. All I cannot say what police wrote. It is not a fact that accused had not disclosed about killing the deceased and had not led the recovery of the Tangia and had not produced any Tangia before police. When accused came to village, my co-villager surrounded him. Accused told the villager that he called the deceased and killed him. I cannot say why accused killed deceased. It is not a fact that myself and the villager threatened accused.
এই যে টাঙ্গিয়াটা কেবে সিজার হলা what is the date of seizure of that Tangia? Seizure list is exhibit 3. Now you see the date. Exhibit 1.
1x. এটা হলো exhibit 3. Accused.
The date হচ্ছে 16/2/2007. 16/2/2007 is the date when this 16/2 16/2/2007. One axe with wooden handle having length of wooden handle so and so.
Length of wooden handle 8 cm.
Showed the statement of the IO, page 45. On 16/2/2007, I arrested the accused, while in police custody in presence of the witnesses. He confessed to have killed the deceased by an axe and concealed this axe in his bedroom, which is under lock and key. The key being with him, I recorded his disclosure statement under Exhibit 2. Accused put his LTA on its Exhibit 2 and 3.
No, we are focusing on that recovery of Tangia at the instance of the accused. As you have said, there are three witnesses on this point. One is PW2, another is PW4, and the last one is the IU. PW2's evidence you have seen that the accused was in the police station and the police went to the house and therefrom he got that Tangia and then brought it to the. So accused had not gone there. And this PW4 has stated that when the dead body was recovered obviously on the date when the FIR was lodged. That is on 14/2/2007. ତେଣୁ ସିଏ କହୁଛି ଯେ ସେତେବେଳେ accused ନଥିଲା ଘରେ ଏବଂ accused came to the village 3 days after the occurrence. ବୁଝିଲେ ନା? ତେଣୁ ସିଜିୟର ଲିଷ୍ଟ ତା ଇନଷ୍ଟାନ୍ସ ରେ ଏ ଯୋଉ ରିକଭରି ହେଇଛି ଟାଙ୍ଗିଆ ଏବଂ that is
not
acceptable. ଆପଣଙ୍କୁ ସିଜିୟର ୱିଟନେସ୍ କାରଣ ଏଇଟା ଏକ ତ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ଆପଣ ଦୁଇଟି ମାତ୍ର ସର୍କମଷ୍ଟାନ୍ସ ଆସୁଛି ଗୋଟେ ଲାଷ୍ଟ ସିନ୍ ଆଉ ଗୋଟେ ହଉଛି ସେ ଯୋଉ ଆକ୍ସ ର ରିକଭରି ଆକ୍ସ ରେ ଆପଣଙ୍କର ବ୍ଲଡ ଆସିଲାନି ରାଇଟ୍ ଆପଣଙ୍କର ଯୋଉ ଆକ୍ସ ଟା ରିକଭରି ହେଇଛି ଆଟ୍ ଦି ଇନଷ୍ଟାନ୍ସ ଅଫ ଦି accused that is doubtful because of this evidence. I had not entered into the house of the accused when he brought out the Tangia. So this statement is also goes contrary to PW2's evidence. And PW2 goes accused totally lying. Accused थाना रे बसी ये कहलानी कि accused जाइथिला एवं recovery होला बाकी evidence कौन रहला 6 नंबर सकी कौन
6 मतलब witness to confession. So the
accused arrested, police arrested him, disclosed report. It was a confession report.
Confession.
Baki, you come to the evidence of the IO, PW7.
On 14/2/2007, I was OIS in the Sadar PS Keonjhar. On that day at 8 p.m., while I was Sukkoti OP under the Sadar PS, informant Srimati Savitri Mahakud, wife of Kalandi Mahakud of village Khajurimunda, PS Sadar Keonjhar, appeared for me, being accompanied by her younger brother Indramani Mahakud, and orally reported about the incident. I reduced her oral report into written under Exhibit 8, read over and explained the contention to her, and she gave his signature in Exhibit 8. Her signature is Exhibit 8/1. Her brother Indramani Mahakud signature is Exhibit 8/2, Exhibit 8/3 is my endorsement and signature. On receipt of the affair, I made a station diary entry number 229 dated 14/2/2007 and took up the investigation. Subsequently, on my return to the PS, I registered the case. That is Exhibit 8/4 is my endorsement and signature. During investigation, I examined the informant and accompanying witnesses and recorded their statement. I commanded Constable such and such to guard the spot. I visited the spot but could not be able to prepare the spot map as it was night. I examined other witnesses and searched for the accused but could not be able to trace him. On 15/2/2007 at 8 a.m., I visited the spot and prepared a spot map under Exhibit 9 and 9/1 is my signature. On that day at 9 a.m., I see some blood-stained earth and sample earth and prepare a seizure list. Exhibit 4 and Exhibit 4/3 is my signature. The same day, I held an inquest on dead body of deceased and prepare an inquest report. That is Exhibit 1 and Exhibit 1 to my signature. That day, 10:30 am, I sent the dead body to the DHS Keonjhar for postmortem examination under the dead body challan, which is Exhibit 10, and 10 was my signature.
The same day, I see the wearing apparels of the deceased and command certificate of the escorting constable under the seizure list, which is Exhibit 11, and it was my signature. On 16/2/2007, I arrested the accused. While in police custody, in presence of witnesses, he confessed to have killed the deceased by an axe and concealed that axe is in his bedroom, which was under lock and key, the key being with him. I recorded his disclosure statement under Exhibit 2. Accused put his LTI on its Exhibit 2/3 is my endorsement with signature. That it is the LTI or accused. So saying accused, Samar Mahakud led me and witnesses to his house and opened the lock of that room and show me that tangia which was kept in the corner of that room. I seized that axe under Exhibit 3/3 is my signature. The same day at 11 a.m., accused produced before me his own garment and the bicycle, stating that he had taken deceased in that bicycle. I seized those garment and bicycle under Exhibit 5 and 5.2 is my signature. The same day at 3:30 p.m., I sent accused to District Headquarters Hospital, Keonjhar, for collection of nail clipping and determination of his blood group. At 5 p.m., I seized from the escorting constable one sealed veil contain nail clipping and
Scrapping of
accused and his blood grouping certificate and command certificate under seizure list, which is Exhibit 12 and 12.1 is my signature. I forwarded the accused to court subsequently. On 11/4/2007, sent to the doctor conducting autopsy the aforesaid acts and made a query under Exhibit 7 as to if the injury of the deceased were possible by that acts and if in ordinary course of the nature of the injury were sufficient to cause death, and the doctor replied in the aforementioned Exhibit 7/3 is my signature. I sent through the SDGM Keonjhar to material object to the SFL Bhubaneswar for chemical examination. Exhibit 13 is the office copy of the forwarding letter of SDGM Keonjhar. The laboratory after examination the furnishing its report, which are Exhibit 14 and 15. After investigation, I filed a charge sheet under charge sheet. Cross-examination. I cannot say if ordinarily tangia were available in village. I have never seen a rural people grazing their cattle. Tangia is a sharp cutting weapon. The wife and children of accused were staying at a telkoi in his father-in-law house. It is not a fact that accused were staying in his father-in-law house. Accused was staying in one room in his ancestral house, and his brother and sister-in-law were staying in one room, and his parents and sister were staying in other third room. The accused had quarreled with his parents and mother of the deceased few days prior to his occurrence. On the date of occurrence, voting for Panchayat election was going on the school of that village. The school was inside the village. I had not gone to that school. I reached Suakati, OP at 8 p.m. The same night, I reached about 9 p.m. and saw the dead body of the deceased. My constable was with me. He guarded the dead body. I searched for accused that night, but he was not found. Between 9:30 p.m. to 10:30 p.m., I had searched for accused. The next day, I searched for the accused, but in vain. I traced the accused on 16th, about 150 meters away from house of accused under the tree. No person of village was present with him. After accused gave a recovery article, he was brought up to PS. My lord. He was interrogated near that tree. Kondara Pradhan and Parikshita Deuri heard the confess of the accused near that tree. It is not a fact that the accused neither gave any disclosure statement nor led to the recovery of any article, and that he was present in house throughout and he was brought to PS from his house, and that I had not asked him anything in village, and that he did not open the lock of his room in my presence, and that the room was not locked. It is not a fact that the disclosure statement was not read over and explained to accused PW1 had not stated to me that accused was a quarreling with all. It is not fact that my investigation was a perfunctory and charge sheet was filed against the accused to harass him and correct by me.
So this tangia which was being carried by the appellant, PW1 has not stated that the appellant carried any tangia. They were in the one is the PW1 is the mother,
Mother.
and 2 is the brother.
Mother.
In that house, they were present. They are stated, and when he came and took Guru, but in a bicycle, both of them, of course, are stated bicycle, but he has stated about that tangia, that accused had a tangia with him, which is not the statement of that PW1. He has simply stated that took him that tangia. And that tangia was not shown to this PW3 also. That this is the tangia which has been carried out by the accused.
Tangia was also not produced in court.
No, my lord, it was not produced.
Tangia not produced, tangia not lost in. That report is there in page number 52. So if the last scene is the only evidence, then the statement of this PW3 that in the afternoon this occurrence took place, and in that afternoon panchayat election was going in the school, and this guru had also gone to that school, and many of the villagers had been to that school. So when that guru again returned from that school in the afternoon, so that he would be carried by this, that is not also, this is something
that has not come to the picture.
କାରଣ ସେ ଯଦି କହିଥାନ୍ତା ହଁ ସକାଳେ ସେ ଯାଇଥିଲା ଅଲଗା କଥା, ସେ କହୁଛନ୍ତି ଯେ ପଞ୍ଚାୟତ ଇଲେକ୍ସନ ଖରାବେଳେ ହଉଥିଲା, ଯୋଉଥିପାଇଁ ସ୍କୁଲରେ ହଉଥିଲା, ବହୁତ ଲୋକ ବି ଯାଇଥିଲେ, ଗାଁ ବାଲା, ଗୁରୁ ବି ଯାଇଥିଲା ସେ ଯୋଉ ଇଏକୁ, ଏବଂ ଏ ପଞ୍ଚାୟତ ଇଲେକ୍ସନ କଥା ସିଏ ଏକୁଟିଆ କହୁନି, ଇଭିନ୍ ଆଇଓ ମଧ୍ୟ କହୁଛି ବୋଧେ ଯେ ପଞ୍ଚାୟତ ଇଲେକ୍ସନ ହଉଥିଲା, ତେଣୁ on the date of, yes, voting for panchayat election was going in this one, so, and the school was inside this one. So that is the, with the DW1,
He himself accused himself.
Father of that deceased.
The 316, 315 never the corruption.
total se mana kurchi mo je on the date of offense, voting for panchayat election was going on this one. I was outside the school at the time. Deceased was not with me then. After the event, I had not escaped, so and so. I have not led to this one.
So he himself cited as a witness.
So, what is your submission, Mr. Parija?
My lord, as there is a time gap of 15 hours as per the evidence of the PW1.
Last scene and recovery of dead body.
My lord. And regarding the
last scene hochi dhara afternoon
1-3
सेना को तारीख ହେଇଥିଲା 13 तारीख डेड बॉडी रिकवरी ହେଲା 14 तारीख କେତେବେଳେ
ସକାଳ କହୁଛନ୍ତି 8ଟା
ସକାଳ
ରାତିରେ ସକାଳେ ଦେଖିଲେ
ସକାଳ ରାତିରେ ତ କିଛି ମିଳିଲା
7 to 8
ତା ଇନଫରମାଣ୍ଟ କହୁଛି ଯେ ଦିନ ପ୍ରାୟ 11ଟା ବେଳେ ମୁଁ
ସେ ଜାଣିଲା
ପାଇଲି। ଆଚ୍ଛା 8ଟା ବେଳେ ମିଳିଲା ବୋଲି କିଏ କହିଲା?
ମାନେ PW2 କହୁଛି I have not seen that on the date of occurrence, elections are going on, and the accused belong to a different side. I belong to different. I saw the dead body around 7 to 8 a.m. Two coach, the witness to the leading.
So that is how you are calculating that it is a time gap of 15 hours.
15 hours.
Okay. That
And
is
the presence of the deceased at the school actually creates doubt regarding the kidnapping of the appellant to the deceased. And my lord, regarding the discovery of weapon of offense, the PW to categorically stated that he was at the police station and while the seizure was made, my lord, leading to discovery as well.
And apart from that,
apart from that, the weapon of offense,
not bloodstain, not produced.
My lord.
So that witness says that he was in the police station when this.
While the and it is seized from the house of the PW1. Appellant was staying in another village. The Tangi, but actually, Tangi was seized from the house of the.
Tangia was seized from the house of PW1.
My lord.
But nobody has seen that when he returned,
the
he was
house.
at Tangia. That is most important.
Either at the time of going or coming.
Time of going PW3 कोची टांगिया लेके जा रहा है one कोहनी
one
तो फेरीला वालों को टांगिया से नहीं कि नस्तिला ये विषय PW1 भी कोहनी की PW3 कोहनी though both of them saw that he returned alone that is yours. Yes, Mr. Naik. What do you say? How this circumstantial evidence, whatever you have proved, it forms a chain so complete that there is no escape from the conclusion that it is the accused and accused alone who has committed the crime. And your main case is based on these two items. One is the last scene, the other is the recovery of the Tangia. Tangia, you have already seen that what are the evidence, even that was not produced and no bloodstain was found on it. And the main item is the last scene. And last scene, this is the evidence that somebody has stated that he was in that school in the afternoon. So many persons were there. So the accused took him to that place. Kidnapping party or charge is framed in 364 way. It has all right. Hard Mr. Vikas Chandra Farija, Learning Council for the appellant, Mr. Jateshwar Naik, Learning Additional Government Advocate, hearing closed, judgment reserved.